Okay, I'm going to call the 1 o'clock meeting to order. It's April the 17th, a little after 1 p.m. And the first thing on the agenda is invocation and pledge of allegiance by Pastor Albert Sanchez from the Community Church of Imperial.
Thank you so much. Let's bow our heads. Heavenly Father, we thank you so much for a beautiful day. We're so reminded of your creation when we live here in the Imperial Valley and see the blue skies and the green fields, the deserts, the mountains, all a testimony to your creative power. We think of the book of Acts that says, in you we live and move and have our existence. And it's because of that power, Lord, that we come together with prayer to look to you as our benevolent God and ask for your blessing upon the meeting and the month. We ask this in the name of your Son, the Lord Jesus Christ. Amen. Right hand over your heart. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Thank you, Mr. Sanchez. Okay, report actions taken in closed session. Mr. Garber, any actions? Closed session?
Actions, Mr. President.
All right, thank you. And we're going to have presentations on service awards, so would the board please step up to the front?
Going up there?
For the service awards, they all read the same except with the name and years of service. And it says this certificate of recognition and service pin replica of the district emblem are presented to, and this one's presented to Eleuterio Ortiz. He's a Sanjero in the water department for 15 years of loyal and faithful service to the Imperial Irrigation District. Come on. For 25 years of service, Billy Reed, Power Troubleshooter Leader in the Energy Department. For 30 years of service, Arthur Bracamonte, Lineman Journeyman in the Energy Department. Is there anyone else here to receive a service award and I didn't call your name? That ends our service awards. Thank you.
Okay, we're going to move on to the approval of the order and agenda items.
Make a motion to approve.
Is there a second?
Second. Yeah, second.
Okay, please vote. All right, thank you. We'll go into public comments, and you have 5 minutes for public comments. Just step to the podium, state your name for the record.
Mr. President, members of the public, my name is Tony Ramos, and I got this hat because I thought it was appropriate that when you live in America, not that they won't want me, that I'm free, because that's an exclamation mark. Nobody would take me probably, except my wife and kids, but and Stella and JP and Sanchez and Garber and probably Mr. Kelly too. But anyway, let's get back to business. You know, that's the beauty about speaking and living in America, because you go right across the board and do what I do, and I've said it before. My wife would probably not have a husband right now. But in America, it's different because they respect people and they appreciate what you do. And I've always would I ever compare myself to Martin Luther King, Chavez, or Mahatma Gandhi. But, you know, these people strive for social justice, social reform, and that's what I'm trying to do here. I get nothing by coming here. In fact, I spent like $1, almost $2, which was a lot of money for me, being that I'm retired, and some copies that I give to the board. And if some people want a copy, I got 3 left here. But, you know, I really believe that Imperial Valley first is what I say is this. I be first and fair to the future of our children. And I also feel that Martin Luther King said it, that an injustice anywhere is a threat to justice everywhere. I use these when I protest against the judges, but what I did today, I just cut and paste some stuff and did some handiwork on myself. And again, I did with what I could. And I feel that Imperial Valley first, and I wrote this as an insert to the advertisements they had. And if I may read, Mr. President, I said, Imperial Group, Colab, and Imperial Valley First are the same people who are trying to sell our water and profit from it. Their Imperial Valley is about money and turning Imperial Valley, or our Imperial, into another Owens Valley. And I really feel that. And the thing is, they got the right to protest, and they got the right to hire an attorney. I can remember his name, to advise him. But the future of our valley depends on keeping Stella and Menville and Mr. Sanchez on the board, because everybody else wants to transfer water and make money from it. People like myself don't know nothing about that. I'm not a farmer. And to me, most of what I do is about representing people, because some people can speak up for themselves. I have nothing against Mike Morgan, against Aaron Mayola, against the groups that I just spoke about. It's just about where I stand. And I hope they respect it like I can respect them. But the main thing here is that of any races, ladies and gentlemen, that we've had in the past years, and I mean it right now, of all the races, whether it's city council, judges, whatever, what have you, the valley has to be self-sufficient and defend itself. And I really feel people like Stella, Sanchez, and Menville stand true to the valley. People have trust in them, and they speak from their heart. They have nothing to gain by selling the water, because people that live in the valley should not be selling the water. And to me, I was going to bring my nephew that came down from Arizona to visit me, but I was afraid that he'd be a little come to seeing his granddad, not my nephew, my grandson, talk in front of the public. And if something happened, I didn't want him to feel that, well, you know, maybe that you shouldn't invite me. So I left him at home. But people, you know, we have to realize that one way or another, there's 3 members there that represent the valley. The other 2, Mr. Desert and Mr. Hanks, I'm not sure about, because you said, Mr. Hanks, that you wouldn't, if it was up to you, you wouldn't transfer even 1 drop of water. But people tend to disagree with you on that issue. And Mr. Ders, you're a good guy. We say hi when we see each other, when we eat and all that. But I put you in the same group as the groups that I just spoke about. So to me, this race is about what's good for the valley. And what's good for the valley is keeping these 3 people on there, and hopefully later on having other people like Stella and Gentleman Pierre Menville and Mr. Sanchez on board. You know, I know that people say, well, it's politics, but it is politics. And people take sides. You can't play both sides. I've never have. And when I came back from the Air Force in 1970, after serving 4 years, I said to myself, what should I do? Well, what I did is what I'm doing now. and I came back to fight for the resources and what's best for our valley. Because if we don't fight for it right now, it's not going to make any sense when all our well is taken. 5, 6, 7 years ago, I had a jug of water, half filled, Stella. And I said, this represents our valley. It was a full gallon of water, and now it's going to be a half gallon of water. Now it's down to a quarter gallon of water if we keep transferring water. And the people who are going to profit. It's not the people that the IB first represents. It's our people that we need to represent. Thank you very much, Mr. Chairman.
Thank you, Mr. Ramos. Mr. Gonzalez.
Thank you. Oscar Gonzalez, 844 Encanto Terrace, Calexico, California. I want to echo what Mr. Ramos basically said, and I think the United for Positive Change in local government is not representative of the community. I think Manville and Mrs. Mendoza are. I think CoLab are a bunch of professionals, merchants, and some farmers. I know Mr. Abadi is on the board of directors, and 90% of our people in Imperial Valley are basically poor. We don't have a middle class in Imperial Valley. The only middle class that we have semblance are teachers, professionals, people that work for the government. So what does it mean if you support COLAC? You're supporting the losers. You got to support the winners. You got to support Manville. You got to support Mendoza, because these people are representative of low-income people. I knew John Pierre's dad when he used to go to Little League games with Mr. Peter Biopi. I played Little League. I was very good at Little League too. But I know Mr. Menville is happy right now that his son is running for re-election again. And I know Mrs. Mendoza's parents are thrilled to death that because you probably have more BALLS than anybody on the board. And I know that because some people don't even want to take a stand. Louis Legaspi, who has Alzheimer's, when he was a supervisor, he took a stand against Turi Armenta. Turi Armenta was a sergeant for the National Guard Army. He was no good. Marlene Thomas, myself, Louis Legaspi, Mike Horn, and Carlos Vasquez from Brawley led the attack. If it hadn't been for Mike Horn, Carlos Vasquez from Brawley, very smart people. Mike Horn is now the director of behavioral health. He gives me more credit than I deserve because he said I showed him some. No, the one that showed me was Louis Legaspi, Spud Moreno, Willie Moreno, Frank Herrera, Alex Campillo, Jack Ortega from the CCAC. I know 30 years ago, there wasn't a FEARS organization, a CCAC. What did we achieve? The only thing that looks like the United States, Walmart, that was our property. The Carrillos, the Morenos, John Moreno's uncle, they fought us. They're the ones we're fighting in Calexico. They're the ones that tried to put me with the restraining order. They hired 3 attorneys. But you know what? I can speak for myself. You know the results? This morning, Tony and I spoke at the Board of Supervisors. Basically what I'm saying, for the same reason. People have to hear it. And it was really disheartening and bullshit what the Ivy Press wrote about Mr. Manville and Mendoza. Yellow journalism, I call it. And all the ads, they can pay for the ads, it's freedom of speech, but you guys have to listen to me because I'm going to say what does it mean to the consumer. And what it means to the consumer, vote for Manville, vote for Mendoza. Gracias.
Thank you, Mr. Gonzalez.
I got 1 minute, last minute. You know what? I'm glad that Governor Brown, with that 2012-13 budget, includes a proposal to eliminate a number of California boards and commissions, including the Colorado River Board. I asked Jim Hanks, how come you don't put Luis Castro? He's not a farmer. Well, you know what? In 1954, you couldn't run for the IID unless you own 160 acres. Mexicans and low-income people have never had input like they have it with John Manville and Estela Mendoza. Believe me, that's the truth. And I'll argue anybody, I'll debate anybody. Since 1911, I know about the Elmores, I know about the Elmore Ranch. They didn't pay taxes for many years. And I know about the Bensons too. They're crooks. And what I'm saying, Benson is an extension of Colab. Benson is a nobody. He's an unknown. Nobody knows him. And yet he says, Oscar, everybody talks about you. He told me, in conclusion, that Luis Castro and I are so controversial. And I said, but you know what, MF? Luis, you need Luis more than Luis needs you, and you need my services more than I need you. Thank you.
Thank you, Mr. Gonzalez. Anybody else? Mr. Morgan?
Oscar, get your car. Mike Morgan, Brawley. Tony, we need to have that once-a-year meeting at the Onion Shed again. There isn't a farmer in this valley who's transferred 1 acre foot. There's not a farmer in this valley that's trying to transfer more by drying up the Salton Sea. There isn't a farmer in this valley who has attorneys that are hired by San Diego developers or work for the Bass Brothers. There's not one of them here that is part of any of the groups you worry about. So come on up and we'll have a talk. But what I have to talk about today is an email that is from Kevin Kelly to Brian Brady. And it's very troubling because through all the years we've worried about serial violations of the Brown Act, where boards get together out of the view of the public. 2 weeks ago, you knocked out a judge that was maybe going to hear the case that maybe saved Imperial Valley. Somebody did that privately. No one did it in public. This email is when Mike Abadi was worried about the liability of the Salton Sea. And he sent something to Kevin or to Brian to ask for an action item or something to be put on the agenda to let the IID know. Mike had been up in the court cases in Sacramento. He had people that watched it and followed it daily. He knew that your attorneys were telling the court that there was no commitment from the state to take care of the Salton Sea, restoration, mitigation, nothing. Mike knew that, so he wanted to bring it in front of this board. So Kevin writes an email, and I'll try and read this, but I don't read as good as I talk. It said to Brian, read Abadi's email. I have talked to John Pierre about it. Think that you should write him back and that you will be prepared to brief him on Monday. I have talked to John Pierre, who has talked to Stella and to Anthony. They are still solid. We have played out this thing for 6 years to get to this point, so why would we budge now? You might also mention to Abadi that you have and will be talking to Osias over the weekend so that you can get his perspective. Still think that finesse is the way to go until you have to hit them hard. What Abadi wants to do is unilateral to understand the Salton Sea. I'm going to leave this for the public here, but it is what's been going on here. Orchestrated by your brilliant lawyers, orchestrated by three people that Tony and Oscar really feel strong of. It is doing business out of the view of the public. It is a violation of the Brown Act. It goes on too much here, and it's another form of corruption. Thank you.
Thank you, Mr. Morgan. Mr. Benson.
Hi, John Pierre and board. I just want to invite everyone at the IID. As the president of the Boys and Girls Club for the Imperial Valley, it's the open house week for Boys and Girls Club. And I'm going to hand these out to you guys. But this is the living proof statement of Boys and Girls Club. We've, since I've been on the board 4 years ago, Raleigh has gone from a point of almost failing. The club was going to close. We turned it around 2 years ago, and now we're opening up hopefully our third club. We opened up El Centro a year ago and opening up a second El Centro club hopefully this summer. Also talking to Calexico, city councilmen down in Calexico are interested in doing it. Also, the city manager of Hopeville is potentially looking at getting on the board because they just had to close their park and rec department. There's a lot of issues in the city, and I hope when you look at the issues in Imperial is interested, and a lot of your workers in Imperial could benefit from this. Boys and Girls Club, if you don't know, it's a after-school program. It serves elementary age kids, and it can also serve from high school teen programs all the way to preparing them for college. The target is at-risk youth, but really it serves anyone that can make it to the club, we charge a nominal fee, $25, and we fund the whole club through donations. A number of the people in this room have been very generous, and thank you for that. And a number of the people listening on TV also. Just wanted to say lastly that I am not affiliated with the CoLab or the PAC. It's been brought up, and I'm sorry I did not hire you as my campaign manager, Oscar. Okay. You can stop calling me now.
Hey.
Anyway.
You guys knock it off or I'll remove you from a room.
No problem. But I welcome you guys to stop by. It is the open house week for Boys and Girls Club. Our national convention is coming up in 2 weeks in San Diego. And this is my second year as president. We're looking to open more clubs throughout the valley. So these are just some facts about Boys and Girls Club. I know you guys have the public benefit money. It could benefit all the youth of the valley. And I hope you guys take them into consideration when we talk about the QSA. Thanks.
All right, thank you, Mr. Benson. Anybody else from the public want to speak? Okay, seeing none, I will bring it back to board member comments, and I'll start with Mr. Sanchez this time. Oh, okay, Bruce, come on.
Good afternoon.
Afternoon, Bruce.
Bruce Kuhn, 1240 Drew Road. I guess I'll take this opportunity to say that I'm not affiliated with CoLab. I'm not affiliated with Farm Bureau. Was, but not anymore. It's just me. 8 years ago, when Mr. Menville ran against me, one of the biggest issues was the water transfer, and he made it no secret that the water transfer was here because I was a swing vote. And now, it was too much water and not enough money. And Tony, I don't know who's transferring water, but we at IID set that up, and we at IID are transferring that water, and it's the same water to which you speak that's being transferred. There are no new transfers, and Director Menville and the other three are supporting that transfer and have been. So I don't know where the water is going to go from half gallon to the court. It's the same transfer. There are no new transfers. The only new transfer that I've heard that's in the wind is the one that they want to take some of the water from the Salton Sea mitigation and transfer it, which would be a further transfer. But that hasn't happened. But that's the only one that's being bantered around. So we're still on the one that was brought here back 8 years ago, and there are no new ones. And that's the one that they support. Kind of went full circle. So I just want to make that clear. But I wish I had my cell phone on and could play the voice messages that Mr. Rodriguez or Gonzalez rather left on my cell phone. It got so bad that I wouldn't return calls anymore. One was quite nasty because I didn't get there in time to pick him up, and he was using the F word and all this. Now this has gone on long enough. I don't think I want him working for me, and I just wouldn't return his calls. But I can tell you now, we went down to Calexico one afternoon, and he had meetings set up. No one showed up. We went the next day, and after buying his breakfast and his lunch, we did meet with about 4 or 5 people, and that worked out pretty well. But when we got back to El Centro, I had to give him $180 to pay for his room because he was being evicted in the motel he was in. And I can tell you that the manager there, I went to him and said, well, I'll pay it, so he can stay. He said, no, he's got to go. So I went across the street. The guy said, no, don't have room here. I said, was he here before? He was here 3 days ago. He can't stay here. I said, oh, okay. Anyway, so we went across the other street and finally found one that he hadn't been in. So I want you to know, Yeah, he wanted to work for us. He wanted to work for Mr. Benson, and he wanted to work for me. And he was able to extort, for lack of a better term, about $200 that day. And then I understand later on he did the same thing to Mr. Benson. So I swear I'm not a deeply religious man, but I thank God that he's working for you three and not me.
Thank you, Mr. Kuhn. Anybody else in the public want to speak? Okay, I'll bring it back to the board. Director Sanchez.
Yeah, I think we shouldn't forget that he's the one that led my recall, for my recall. So I don't know if he's actually working for me, but I am requesting that the general manager to prepare a 2-year plan to freeze the salaries of the top 25 managers at IID, beginning with the year with the 2013 budget. I would like to see that plan come forward as an informational item and ultimately for action as soon as it is practical. Now, the first time the district did this, I was on board in 2007, where we froze the salaries of the entire staff at IID because of the Great Recession. And I think it's important to, I know there's some concerns out there about our executive management and their salaries. And I think we need a pause, take a 2-year freeze on all those salaries until we can get those under control and take a deeper look at it. Thank you.
Director Mendoza.
I have no comment.
Okay, thank you. Director Desert.
Yeah, I concur with Director Sanchez's comment about the freeze, but we need to take it a little bit further than that. We've been under criticism and scrutiny over these salaries, amongst some other issues. And Mr. Kelly, we need to take note of the corrections that you've made in the alignment of these contracts. Last week I asked you about an update of our 6-point plan, or your 6-point plan, and hopefully we'll get a report of that today. The salaries, once they get locked in place, they're difficult to negotiate down and correct. The salaries are the highest around. We have a significant number of people making more than the CEO executive officer at Imperial County. Significant amount of employees, managers making more than superintendent of schools. Some other departments that these people manage don't have that many people to take into consideration. I'm not quite sure how the salaries grew over the years. I think that's something that staff needs to be cognizant of now, because the public is, and so is the board. We need to have that discussion with our council and our HR director, Mr. Kelly, to take a look at that and under whose watch that happened, and what was the timing and events, and was the board involved. There's been some corrective actions taken where these contracts now can't just be signed without bringing them to the board. There's some limits set as to what the dollar value is, and there was some blowback from staff in getting that language put together. But now that Director Sanchez has brought it forward, I concur with him, and we need to take even a further look at that. We need to take a look at employees that have been redlined and employees that have had desk audits and been moved up or down, and see if that kind of consideration was ran by the general manager or the board. Our salaries are high. They're the highest salaries in the valley. These are the best jobs around, and we don't want to take that for granted and send the wrong message out there. The second comment is on real estate ads that took place this past Sunday. We were in discussion about selling some properties. The board decided to fly those properties and then advertise those first to make sure that we're being transparent and then everybody can see what's going on. These ads were not uniform in nature. They were 3 separate pages in their locations. I don't understand why they weren't just one large ad listed specifically by canal and gate, the acreage, perhaps the APN number or crossroads. For some reason, we put language on there that refers to the original property owner that sold them to the Western Farmlands. Many people don't recognize those. Many farmers and people in the neighborhoods don't recognize those names, but they do recognize the canal and gates, just like we recognize street names and freeways and interstates. That's the language out in the ditch bank, and that's what should be used. The good thing is that they were flown. I just hope that we can continue to move forward and make some corrections and changes there and do a better job there. We have an item on today's agenda, the purchasing and procurement policy review. There'll be comments at that time. I just kind of wanted to touch a little highlights on that before we get there. There was some unfortunate language and talk at the last board meeting and discussion of this item. And for board members, as well as management administration at the IED are involved in this type of activities, you know, they tell you have to have a thick skin. And I've learned that, and you do have to have a thick skin. It is unfortunate that those words and language gets used, but it's also equally as unfortunate that the public sector, those groups, and this happens to be CoLab that's involved in this also, don't have the ear of the IID, and the IID doesn't seem to listen. The only way the IID seems to listen is if someone has to hire an attorney and file a lawsuit, and that truly is unfortunate. I'd like to see changes away from that and where we can work together. IID staff working on this have stuck to their guns. We've come up with some better language, but unfortunately, I feel that language can be interpreted where the IID can do just as they've always done. Perhaps they could always do that. Humans could always interpret the language to do and make those decisions. But staff members, you need to understand the amount of time and expense that has been put together on this, and the discussion, the meetings, the review of these policies, the newspaper articles, because the decisions there that you've made put it right on before us, the crosshairs on us. And the tipping point on all this was simply a weed spraying contract, spraying our canals and drains. So we're here today. We'll be discussing that in action. Hopefully we'll get to some resolve. And Mr. Kelly, when we get to reviewing this purchasing and procurement policy again, I don't know if we'll do it in the immediate future or if we'll do it a year from now. But when we do, we need to follow what the Imperial County does. And in my past job at the Imperial County Air Pollution Control District, I was fortunate enough to work with staff there and work on policies and rules regarding air pollution control. And everybody needs to know that the Air Pollution Control District isn't perceived to be a warm and fuzzy place in the private sector. But the way we put it together there, the way it was put together there when I was employed, was we created a technical advisory committee, stakeholders group, where they participated hand in hand with the development of the rule and policy and steps. It wasn't put together all at once and then submitted to someone else for review. And I highly recommend that we consider the actions and steps that the county takes in developing these difficult rules and policies for something as beneficial as economic development and the expenditures of the IID through purchasing and procurement in Imperial County. Thank you.
Thank you, Director Desert. Director Hanks.
Just like to make a couple of comments. We have a loaded agenda today with a lot of big ticket items, very important issues. And as in most of these meetings, we're on TV and we're all that. But at the end of the day, you know, just like the people that came up here and accepted the service awards, the water dispatcher, the Zan Heralds, power shooters, troubleshooters, linemen, operations people, and engineers. At the end of the day, those are the ones that get the job done around here. And sometimes we lose focus of that. I think kind of where we're headed today is kind of an indication of it. And I just remind everybody, whenever you're out there and you hit that switch, if you knew all the work that went behind that, and people never get any credit for it, it's pretty awesome whenever you get inside here and you start learning these things. So all these things that we're going to do are important today, but let's don't forget what the purpose here, and that's to keep this water flowing and the power on to you. Thank you.
Thank you, Director Hanks. I have no comments. I'm going to move on to the General Manager, Mr. Kelly.
No, I have nothing.
Thank you, Mr. Kelly. Mr. Garber?
No comments, Mr. President.
Thank you, Mr. Garber. We're going to move on to consent. There's two items for consent So is there a motion for consent?
Motion to approve.
Is there a second?
Second.
Okay, please vote. Thank you. We're going to move into the first informational item, which is legal number 3, page 33. It's a legal update by Alan Matkins on quantification settlement agreement and state petition. Mr. Keller, you're going to handle that? Okay, David, go ahead, Mr. Garber.
I think Mr. Osias and Mr. Haddam are here to give you an update on the QSA and other matters that they're handling. I'm going to pass it on to them.
Good afternoon. David Osias of Alan Matkins. It's been a fairly long time since I've addressed you in public. It's nice to see everyone again, both on the board and in the public. I understand that you've had a variety of updates from others, and I appreciate this opportunity to talk a little bit about the litigation, the state board petition, the QSA, and the concerns I've heard about it. I thought I'd start and at least remind those who don't get to participate that we've been periodically updating the board in closed session about the QSA litigation. And this is just those sessions that we've participated in since the trial court decision, which we ultimately had reversed. And as you can see, it's quite a few. I have a 2-page summary, which will be followed by some materials in detail. So if you'll let me hurry through this, what I intend to cover is a litigation update. The short news blip would be IID continues to win. As recently as April 6th, it prevailed in another lawsuit, which I'll discuss in a moment. The success it's had have come in front of judges in at least 3 different counties, multiple different appellate panels, and 3 separate federal judges. Second, where does the QSA lawsuits go from here? I'll talk a little bit about that. That's the second bullet on this page. Third, what's the status of the state board petition to modify a mitigation schedule? Next, I'll talk a little bit about what the QSA has been successfully doing since it was signed to protect the water rights. In particular, I'll note out right now that since 2002, the connection that exists between efficiency, environmental impacts, costs of conservation, and costs of mitigation have been tightly tied together. They were presented to the state board in 2002. They've been relevant to the QSA transfers, and that link, which was ignored, frankly, by the Bureau in 2003 when they did the cutback and issued their 417 decision, which has nothing to do with April 17, which is also called 417, which is today. They ignored environmental impacts and the costs of mitigation, but the state board did not, the QSA contracts do not, and we think it's to IID's protection that this linkage has been made. Also, we'll touch on some opinions that have been circulating that the QSA does not pay enough money to the IID for IID to implement it and mitigate as it's agreed to do. And frankly, some of the comments from Mr. Dumars on the subject of the QSA and financial impacts and legal things, I think mostly based on probably inadequate time to review a very extensive history. And so some of them are poorly informed, incorrect, or irrelevant. So starting with an update of the lawsuits, just related to the QSA now, not including the All-America Canal component and the Western Farms land purchase, not other suits that have been filed about equitable distribution and other sort of issues. There were 15 lawsuits and 3 cross complaints filed against IID. IID, of course, filed one lawsuit just asking a court to determine that the contracts were valid. No other relief sought. These lawsuits all seek to set aside the QSA. Some of them sought damages up to $25 billion, attorney's fees up to $50 million. And essentially were about trying to assert control or influence over the IID board with respect to water transfer, and water policy decisions. So the scorecard, if you're inclined to keep one after 10 years of this, the 3 cross complaints were all dismissed. 9 other cases were dismissed and are final. 1 is dismissed and on appeal and waiting a state appellate court decision. 1, as of about 2 weeks ago in federal court, judgment was granted in favor of the United States and the water agencies and against the county and the air district. Their appeal period is running, and I just heard that they've chosen to appeal. I guess that won't surprise anyone. And 4, 2 CEQA cases and 2 Western Farms cases, and then the residual of the validation case remain to be resolved. Now, it says see handout, and I've given the Secretary a list of these cases and who were the plaintiffs and who was involved and the results, and that'll be made available to the public. So what about the litigation? Well, it's been expensive for everyone. Each side is, of course, paying their own attorneys now. Given the results, I'm not sure why the people challenging the QSA continue to fund that litigation. It's been fruitless so far. No success. And frankly, the courts have routinely found the arguments against it to be meritless. There was only one that was questionable. That was the one that was made about constitutionality, and the appellate court said that trial judge was flat out wrong also. Let me just illustrate some recent language from those cases so I don't have to paraphrase them to drive that point home. So the appellate court rejected the claim of the County of Imperial that they had a say in approving or setting conditions on the QSA under the wheeling laws. And if you take a minute to read the screen, the court's language is pretty simple. The statute unequivocally refutes the county's argument. Second, the county alleged that NEPA compliance by the federal government, that's the federal version of CEQA, was violated with respect to the QSA, and they brought suit in federal district court in San Diego. And as I said, that decision came out April 6th of this year. The reason that decision is so late is they filed suit on the second to last day that you could file suit before the statute of limitations run, and that was 6 years after the feds had issued the environmental review. In any event, this is all in quotes because this is what the district court found about the county's case just recently. It says the Bureau of Reclamation properly considered potential impacts of its proposed action on the Salton Sea. Importantly, the transfer EIR-EIS, and IID's transfer EIR, by the way, is the CEQA side of this joint document. So importantly, the transfer EIR-EIS thoroughly considered these issues, and that detailed analysis was incorporated by reference into the final EIS. And the EIS is the federal document. Quote, the transfer EIR-EIS examines in great detail the potential hydrologic impacts of the proposed IID San Diego water transfer and conservation measures on Imperial County and the Salton Sea. The argument, of course, by the county was that all the impacts had been swept under the rug and hidden and weren't thoroughly reviewed. And the judge said, no, au contraire. In fact, they were very detailed analysis. The court went on to say, because the Salton Sea's salinity and elevation will change without the project, the court agrees that the most accurate way to assess the project's impacts is to compare it to a future baseline, as federal defendants did here. The court goes on to say, by contrast, comparing it to a current conditions baseline would not factor in changes that will occur regardless of the project, effectively overstating the project's impacts. Now, the county and many of the challengers to the QSA have been blaming all Salton Sea decline on the QSA. And in fact, the QSA, when it stops mitigating with water to the sea, will cause the sea to go down sooner than it otherwise would. Ultimately, it will end up in the same place. But that hasn't occurred yet. And in evaluating the cause of the sea going down, comparing what the QSA will cause to what would otherwise occur anyway is what the federal court said is the right way to go. Now, the appellate court, which is an older decision, this was just around New Year's, and then, of course, more recently, the Supreme Court denied review. So this is a final decision, determined that the QSA didn't violate the California Constitution as found by the Sacramento Superior Court. Again, reiterates what the contract means, which is we conclude, that's the appellate court, they are wrong. Who? The parties who contend it violates it. We conclude they are wrong because the state's commitment to pay the excess mitigation costs is contingent on there being excess cost to pay, and a contingent obligation does not qualify as a debt or liability within the meaning of that constitutional provision. Until the state has to pay, meaning the $387 million contributed by the parties is exhausted, it's not a debt. And therefore, it can't violate the limit on debt, which, by the way, is like $100,000 for the entire state. It's an obsolete provision. And obviously, the state and other parties who do business with the state have lots of contingent obligations that don't violate the Constitution. The appellate court understood how to read the language of the contract and read it correctly, even though the trial court tried very hard to ignore what it said. The appellate court correctly said, if the conditions for the state's payment of excess mitigation costs were to arise, but the state refused to appropriate money from the Treasury to pay those costs, then the irrigation district, Coachella, and San Diego would have a breach of contract claim against the state based on the state's breach of the Joint Powers Agreement, and the state would not be able to assert the lack of an appropriation as a defense to that claim. That's what the contract said. This is what Judge Candie read to mean if they can't raise it as a defense, apparently the irrigation district can just reach into the Treasury and grab money without an appropriation, and the answer is no. Nobody can do that. Nobody who contracts with the state can do that. All you can do is sue the state for breach. The court went on to say, nevertheless, even if the water agencies obtained a judgment against the state, they could not force the state to draw money from the Treasury to satisfy that judgment because the separation of powers doctrine precludes the courts from compelling the legislature to enact an appropriation measure. This is true. This is true for every contract that the state promises to pay, whether it's renting a building, paying for environmental mitigation, leasing vehicles. Its promise to pay is a contract. If it doesn't perform, it can be sued for breach. If the winner gets a judgment, then the legislature has to appropriate to pay the judgment. People have taken this paragraph to mean, see, the state's off the hook. That's not so. Court went on to say, well, that possible result might appear to make the state's obligation to pay the excess costs illusory. It does not. This is so because a contract with the government cannot be found illusory just because the legislature can refuse to appropriate the funds necessary to perform its obligation under the contract. Otherwise, many contracts with the government would be illusory. Additionally, it must be noted that just because the legislature might, hypothetically, refuse to appropriate funds for the specific purpose of paying the excess mitigation costs does not necessarily mean the water agencies would be left with no ability to enforce the state's obligation to pay those costs. So whoever's walking around saying it's unenforceable is wrong, according to the appellate court. This leaves the water agencies the opportunity to enforce the state's obligation by reaching other funds that have been appropriated already for purposes consistent with environmental mitigation for which the state is financially responsible under the Joint Powers Agreement. Now, there's another question that arises. If you're talking about contracts and judgments with the state, question, does the state ever appropriate money to perform its contracts? The answer is all the time, every year, lots of them. Well, if it doesn't have to, why does it do that? Answer, because no one would do business with the state if they didn't. And the state interacts with the private market all the time. It borrows money. To pay back the money, it has to appropriate funds. Could the state live without borrowing money? Unfortunately, no. Do the people who lend money to the state expect the state to appropriate money to pay it back? Yes. Can they reach in and grab the money without an appropriation? No. Does that chill the bond market? No. The state performs its contracts, or people will refuse to deal with the state. But sometimes it breaches and it gets sued. And then does it say, nanny, 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 I don't have to pay? No. The state appropriates money every year to pay judgments. Lots of money. People assume this contract will be the only contract or an unusual contract, and the state will not either perform it or, after it gets a breach of contract judgment against it, appropriate money. As far as I can tell, no one has researched why they think that's so. It's just a useful conclusion, apparently. It's wrong, and people should stop repeating it. The appellate court also rejected this theory that, in fact, the deal made doesn't mean what the parties thought it meant, and so there was no meeting of the minds. And they specifically singled out the Morgan-Holtz parties. Court said, in the view of the Morgan-Holtz parties, these differences mean that the collective minds of the decision makers never met. Court says, but even if we assume the arguments are properly before us, by the way, it also found they weren't properly there, court went on to say, we find no merit in them. Quote, reading the statement of decision as a whole, it appears the trial court concluded there was a meeting of the minds, albeit a meeting on terms the trial court found unconstitutional, but we do not. So as a result of that appellate decision, we're back to the Superior Court to finish the case. And this is the schedule of what happened. The appellate court sent it back on March 19th. Judge Candy mailed a notice of a status conference on March 28th, setting a filing date of April 16th and a hearing date of April 23rd. IID filed his peremptory challenge on April 3rd. On April 9th, Judge Candy vacated his notice, and also on April 9th, the presiding judge assigned a new judge. So now we have a new judge very promptly, and this case will continue. What's left? Well, the new judge will set a status conference date. That's a organizational hearing. When should we finish the trial? How long will it take for people to get ready? Do I need any additional briefs? Have you worked things out already? And then we will resume. So what's left? Well, there's a few non-CEQA validation issues left. In our opinion, those are very weak challenges. And none of them rise to the level of invalidity, even if there's an error made. And there's the CEQA challenges. Now, the CEQA challenge to the transfer project EIR, as you can imagine, brought by the county and others, is very similar to the NEPA challenge to the EIS that they just lost. Not identical, but very close. There's also a CEQA challenge to the overall QSA program EIR. And the important thing to note is, unlike validity, something's either valid or it's invalid. You can't have it be in between. A CEQA defect allows a judge to do lots of different things. It can say, you should have considered an additional alternative, go back and study that. You should have required more mitigation, go back and study that. You didn't give enough time for people to comment, go back and give people more time. But a judge is not required to stop the project while that additional review goes on. A judge can, but is not necessarily so. So CEQA defects do not necessarily produce invalidity. We also have pending, as your agenda item noted, a petition before the State Board. That's filed on October. Opposition deadline expired January 2012. I was shocked, but some group of farmers filed a protest, and we expect that'll be resolved in 2012. There are also protests for environmental impacts that might be caused by the change, which I'll walk through in a minute. And the State Board is allowing those placeholder protests to be on hold until the environmental review process for the change is completed. We expect a hearing in mid-2013 after the EIR studying the impacts is released, so people can see what the changes would be, what the alternatives are, what the potential impacts would be, what the other substitute mitigation might be, and then the State Board will make a decision. This is only a request to modify the existing order that approves the transfers. This is not a new request in any way. It's a modification. It's a request to modify the state's existing order. If this request is denied, then the order will stay the same. Now, a couple of the protestants, especially the farmers, think that the State Board should open this up to determine water rights. That's not even part of the request, and I don't think that'll get very much traction. Now, what's the background for this petition? Well, this is the current mitigation schedule for impacts on the Salton Sea. It started in 2003, and I've only put up the current to the future. It involves putting water in the sea in an amount equal to the water flow to the sea that's cut off by the transfer to San Diego. And in 2012, we're required to put 45,000 acre-feet of water in the sea, and IID will be paid $5.2 million for that. This is the schedule for each year and the volume of water. The petition suggests that we not put water in the sea as a mitigation tool for 2014, 2015, 2016, and 2017. If that request is granted, 61.7 million of the 75 million will be saved and spent on other mitigation. It'll be better mitigation. Why do I say that? Because the benefit of putting water in the sea protects elevation and salinity for a couple years, has no enduring benefit. And it stops in 2017. If you spent $62 million building air mitigation structures, moat and row, or putting on surfactant to keep it from blowing or doing other things, and you build some ponds for habitat, those will last the life of the deal. You can spend $62 million a lot better and have an effect that mitigates sooner, better, and lasts longer. And that's what the petition is asking the State Board to approve, and that's what's being studied by the current environmental. Now, it's been a long time since people talked about the QSA and water rights protection. It seems to have fallen out of the dialogue as people debate issues about money. But frankly, it was signed as a tool to protect the IID's water rights, and it's done that. Unlike the contentious history from the mid-'80s through 2003, when there were attacks on IID's water, there have been no external challenges to IID's reasonable and beneficial use since the QSA was signed. There's been no Part 417 challenged by the Bureau since the QSA. There's been no State Board concerns with IID's water use or the reports we give them about the QSA transfer progress since it was signed. There is one dispute with the Bureau and Met about our mitigation water that was put in the sea in 2010 for storage. We're working on solving that. But even that didn't erupt into the lawsuits that took place in the 90s and 2002 and 2003.
Part 417 is?
Part 417, I'm sorry. General Counsel said, explain Part 417 in terms of what it is. Part 417 is a regulation adopted by the Bureau of Reclamation asserting that the Bureau has the right to review reasonable and beneficial use of Colorado River contractors other than those who divert from municipal use. And in that sense, it's a asserted parallel to the state mechanism that the State Board does. IID actually doesn't believe that Part 417 is valid, and when the Bureau invoked it in 2003 and took away 300,000 acre-feet of IID's water and gave it to Coachella and Met. IID sued, said it was both a invalid regulation and improperly implemented. And the judge agreed it was improperly implemented, reserved the question of whether it was valid, and enjoined the cutback. Some farmers supported that cutback, frankly, which was surprising. And that support was used by the U.S. to try to defeat the injunction. But in any event, that's a procedure that's been put on ice by the QSA. So what benefits besides water rights protection? Well, the QSA has paid and will pay for its cost of implementation. Mr. President, do you want me to wait until we have people back?
No, I think from a time standpoint, just keep going.
Okay. So it's going to pay for IID's costs of implementing the QSA and IID's share of the mitigation costs. It's going to produce efficiency-based conservation over the long term. Of course, we all know that in the short term, we had fallowing, and we're ramping up our efficiency now. We're up to about 21,000 acre-feet of efficiency and still about 90,000 acre-feet, I think, of fallowing transfer. But it'll eventually become 300,000 acre-feet of efficiency. It also helps IID pay for delivery system improvements, which saves water and also makes it easier and more effective to do efficiency improvements on farm. And IID will get a large portion of its transfer volume on farm. The QSA also allows temporary fallowing for transfer, and the law says during the QSA, if there's a reasonable and beneficial use dispute, fallowing gets to be treated like it was efficiency for figuring out IID's reasonable water use. IID can choose to create conserved water for Coachella in any manner it wishes, including temporary fallowing. It's up to IID. There's no QSA restrictions. And the law that was passed to facilitate the QSA includes temporary fallowing on a long-term basis. Sounds like an oxymoron, but it's specifically defined. And that could allow it to be done for solar projects. It doesn't require it to be done for that. So in light of those benefits and attributes and the court rulings, why is there so much criticism in part by Mr. Dumars and in part by everyone else? Well, I can't speak to the others who've been here a long time and have an agenda. But Mr. Dumars, I think, probably was not able to digest the information in the time he had. Obviously, the legal, historical, and factual background is critical to understanding, evaluating, and commenting. Now, he says in slide 6 that they reviewed, his firm, LRPA, reviewed all relevant financial documents, all contracts, all conservation-related documents, and environmental information relating to air quality, mitigation effects on the Salton Sea, as well as all of the relevant federal and state laws, court decisions, and all other QSA obligations of the IID. He said at the hearing that he looked and evaluated all of the documents, the federal and state laws, and the decisions and the QSA obligations. In essence, quote, we looked at the whole thing. He complimented IID staff for making available to his team everything they requested and with helping them understand the facts. Now, this is small print. I apologize for that. But frankly, if he looked at everything to really understand what was going on, starting with the decision he chose to look at, which was Decision 1600, it'd be about 1 million pages. That's a lot of reading. And even if you read it, because some of it would be overlapping, it's a lot of understanding. And he didn't have that much time, and so perhaps this is why he made the errors he did. I don't necessarily fault him for that, but I do think it needs to be kept in mind. So what are some examples, just illustrative errors, that Mr. Dumars made? So I quote slide 13, where he says, quote, a coalition of political forces, including the U.S. BOR, the MWD, and Mr. Elmore, participated in the case that resulted in SWRCB decision number 1600. He said at the meeting, quote, decision 1600 was the product of this will all be documented, comma, but I think everybody realizes it was a product of forces of the United States Bureau of Reclamation, Metropolitan Water District, seeking to move water out of ag and over into urban use. And unfortunately, Mr. Dumars is just wrong. Decision 1600 was not influenced by a conspiracy between MWD and the BOR. In fact, MWD refused to participate because they were fighting for the peripheral canal. And BOR did participate. They submitted a report saying IID was as reasonable as every other irrigation district using Colorado River water. And they even produced a witness who testified to that. Now, Mr. Dumars, in his working his way through the materials, may have been thinking of a period that started about 8 years later and continued into the 2000s, where Met and the Bureau, in fact, were conspiring to get IID's water. And that was what ended up in the courtroom in 2003 when the IID had to sue the United States to get that water back, and was fortunate enough to get a preliminary injunction and did so. But that wasn't just in 1600. And so, that's fairly fundamental. He chose to start with that, and he got it wrong. He also says in slide 15, the IID should take the formal position that SWRCB 1600 must be reversed due to its demonstrably faulty factual premise and accordingly flawed inference of waste. He said orally at the meeting, and I am first to say that issue that started in 1984 with a horrific, incorrect decision about whether or not IID is a wasteful entity and has proceeded forward. Mr. Dumars suggests in his presentation, both orally and in slides, that IID flows into the Salton Sea back then, generated power, and supported a habitat. So ergo, it couldn't be a waste. Well, that was the identical argument that IID made. Exactly that argument. And they lost. The state board said, no, that's not right. Look at the last bullet. The state board said, your tailwater's causing flooding. And although I didn't quote it here, they also said, and the benefit to the habitat is very temporary. You should be able to save some of that and transfer it. And under those facts, at this date, it's a waste. Now, why not get it reversed? Well, you can't. IID lost. They went to court. 2 appellate courts ruled against them. It's a final decision. It's not reversible. More importantly, why would the IID want to spend its efforts criticizing a decision that's almost 30 years old, when it's no longer relevant? Accusing the state board of pandering to the Bureau, which is wrong, and Met, which is wrong, to get to a result which is no longer relevant, while we're asking the state board to improve the mitigation plan, seems to me, just my opinion, to be ill-advised. You don't need to do it. The state board heard all about the IID's dilemma in 2002. The Bureau thinks the IID should be more efficient. They were conspiring with Met. Everyone needs more water supply, but there are environmental impacts caused by becoming more efficient, and IID needs to get enough money to pay for becoming more efficient and to take care of the impacts that you, State Board, think are important enough to worry about. When they improved the transfer, the State Board decided what impacts needed to be mitigated. Only some of them, only for a period of time. So there's no reason to go back and fight an old decision. We have a new decision in 2002. We're going to get another new decision in 2013. Mr. Dumars suggested a strategy of linking IID efficiency and environmental impacts because those add costs, and that lessens the pressure on the IID. He's right. It's a good strategy, one that IID has adopted and been implementing for a long time. In 2002, you can see the argument that was made to the state board by IID. It ended up in a balancing by the state board in approving the transfer. So I don't fault him for the idea, but it's not a new idea. He does make some material errors, though, and those I think are important to focus on. His errors are mostly in assumptions. He assumes that QSA mitigation expenses will vastly exceed the funds available. Even though we've been working now for, where's Bruce? I don't know, 3 or 4 years on pilot projects and have learned quite a bit about how to mitigate air and create habitat at a much lesser expense than was originally projected in 2002 before any of this had started. I understand Mr. DeMars met with people and got that information, but he assumes it will be vastly exceeded. I mean, it'll be 4 or 5 times the cost of this number. He also assumes the state will not perform its contractual obligation by appropriating money to pay for any excess mitigation costs. He doesn't say why he assumes that. He doesn't say, geez, I went and looked, and the state never appropriates money to perform contracts. He also assumes that ID will not be able to enforce a judgment against the state, against funds already appropriated, contrary to what the appellate court actually said. And he assumes the state will not appropriate money to satisfy a judgment and allow the QSA mitigation costs to be paid. To compound those errors, he then assumes that ID will volunteer or have to pay the QSA mitigation costs, even though it has a statutory and contractual protection that those costs will not be paid by ID. This one befuddles me. Why would he assume ID will volunteer to do that? I don't know. Why does he assume someone could impose that when it's against the express terms of the contract and the law? I don't know. He quotes the court, but he gets this wrong. He says, the decision in the Court of Appeals that there was never the intent of the IID to actually hold the state of California to its obligation to take care of restoration and mitigation. That's not so. Court didn't say that, first of all. IID never said that. And I'm not sure where he got that. He went on to say the QSA presumed that the state would cover the excess environmental mitigation cost. Well, that's a little unfair. The QSA contracted, made the state promise in writing, enforceable with a judgment, that it would take care of the excess environmental mitigation costs. Much more than a presumption. He goes on to say, quote, but since this will not occur in practice, the ID is bearing the risk of the state's default or potential default. I don't know why Mr. Redmond of Mr. DeMars' office reached that conclusion. Maybe he knows that contracts are not performed by the state or judgments not paid. I don't believe any of these assumptions have any factual basis. If you said, well, Mr. Osias, did you look to see if the state pays judgments? The answer is not for very long. I had a paralegal spend about a half a day, and he found tons of examples, including a $45 million judgment that was paid by an appropriation, an $8 million judgment, a $9 million judgment. Remember, the state only has to pay on an annual basis, so it's not going to be a lump sum for the whole balance. How about appropriations to perform contracts? Yeah, it's in every budget. So there's something. I'm not an expert on state appropriations, but you can find examples of big numbers being appropriated for judgments, settlements, attorney's fees, things that people don't like to pay, and obviously contract performance, which the state does want to perform. So why these assumptions were made, I don't know. I think they're wrong. I think it's ill-advised to get everyone worked up about it as a belief that the state has reneged. The state hasn't breached. They don't have to pay until the money runs out. They haven't said they won't pay. No excess costs exist, and so they're not yet in breach. Nor do we have any reason to believe they will be. They regularly appropriate money, as this says, and to pay judgments and perform contracts. More fundamentally, why would IID volunteer to do it and get stuck holding the bag? The law says we don't have to pay the QSA excess mitigation costs. A statute was passed to this effect. The contract says IID does not have to pay excess mitigation costs. So how do we figure out whether there will be excess mitigation costs, and will we get surprised by it? Well, the answer is we are a team member of a three-party team: Fish and Game, Fish and Wildlife Service, and IID. In fact, Mr. Wilcox. Identify what annual mitigation is needed to mitigate the effects of the transfer and what it costs to perform it, and identifies it in advance and submits it to the JPA, whose obligation is to fund it. Okay? If it doesn't get funded, IID won't implement the mitigation. Well, what gives us that right? Well, the state board said, we approve the transfer if you do the mitigation. If you don't do the mitigation, we don't approve the transfer. IID can't transfer without doing the mitigation. No money, no mitigation, no transfer. Otherwise, IID violates the state board order. So if IID can't transfer, then IID won't create the conserved water and transfer it. And if it doesn't create the conserved water and transfer it, the environmental impacts from creating conserved water and transferring it won't show up. And if they don't occur, then why would a financial summary in Mr. Dumar's presentation assume that the full term of the QSA environmental mitigation costs above the money is completely paid by the IID? Whether the number's right or wrong isn't the relevant point at the moment. It's why would he assume it would even happen and the IID would pay it and that would come out of the QSA? That assumption is a fairly important one and I think erroneous. So I don't think it's helpful to IID to have advisors suggest that it will pay. The state will pay. If the state doesn't pay, someone else will pay or the transfer will stop because it has to stop. And at that point, the mitigation will no longer be needed because the transfer impacts will no longer occur. He makes the same sort of mistakes about restoration. He assumes that because the state identified a preferred alternative, I should back up and be specific, because, the Department of Water Resources identified a preferred alternative in 2006, which they estimated would cost 8.9, I rounded here, sorry, but so did he, 8.9 billion in 2006 dollars to implement with no financing plan, submitted it to the legislature, and it wasn't accepted by the legislature. He's assumed, A, that project will happen, and B, IID will volunteer to pay 5% of it. That project will not happen. Nobody, I think, believes that the state's going to implement the $9 billion preferred alternative. IID is protected by law from having to pay for restoration costs other than what it contracted to pay to the restoration fund out of QSA revenues. It's protected by another law from solvency liability. It's protected by its QSA contract from restoration costs. And it certainly shouldn't assume or discuss volunteering to pay 5% of a preferred alternative that's at least $9 billion when you escalate from 2006. He also sends some stuff that's a little bit annoying, mostly irrelevant. Slide 20 talks about how the actions of the IID over the past 15 years have been driven by litigation, directed by attorneys representing the IID on legal and factual issues. Now, I don't know if he means the litigation was directed by attorneys or the actions of the IID have been directed by attorneys. If he means the actions of the IID, A, is wrong, and B, it's insulting. I don't think this board has all these meetings and has all these votes because they've delegated their decision-making to someone else. And if he's talking about the litigation, he's still wrong because litigation decisions, who to sue, who not to sue, whether to sue, are made by the board. Did the board approve the suit against the United States? Yes, it did, before it was filed. Did it approve the one suit about the QSA, which was to determine only that it was valid? Yes, it did. Did the board approve getting sued in 15 suits and 3 cross complaints? It didn't, because it didn't have a right to approve that. It did choose, though, whether to defend or not, and it said defend. By the way, it said and win. We've been trying to do that. So when Mr. DeMars is critical about all this litigation, who's suing who for what? Well, every challenger to the QSA is suing the IID to try to get control over water issues. The IID is merely suing to make sure that the court rules that the QSA is a valid contract. And when you see the list, you can see the number of suits. So unless the goal is to lose the suits, I don't know what Mr. DeMars is being critical of here. He repeated it, though. He thought it was important enough that because of this lawsuits, mostly by people suing the IID, the board can't communicate with these people as well as it might without them. My suggestion, drop the lawsuits against the IID, accept the QSA is valid, and move on. Implement it well, spend the money wisely, protect your water rights. Not very difficult. But people sue all the time, and it's gotten to be a common and predictable occurrence. I'll admit this annoyed me. He said, one interesting fact was not a single lawyer for the IID contacted us to provide us any information about this matter. To which my response is, not one lawyer from LPRA contacted us to ask for any information, including stuff that wouldn't necessarily be in documents like, what was your strategy or anything like that. On the other hand, I'm not surprised they didn't contact us because they said they reviewed and understood everything. We were told not to influence them and not to contact them, so we didn't. Staff gave them information and have corrected some stuff that has yet to show up. So that's where we find ourselves, and I'm available for Q&A.
Okay.
Or not.
Yeah, no, that's fine. That's fine. First of all, we'll deal with the board. Does the board have questions for Mr. Osias on the PowerPoint he just went over? And then we'll take questions from the public.
That Mr. Dumars will be back in June.
He'll get a copy of this, so I assume he'll try to address some of the assumptions.
Mr. DeMars will be back on the first meeting in May.
And the first 2 meetings, I as well asked him, where are your benchmarks? Where are the examples? Because he's a lawyer. He knows in every court case that he goes to, he cites either precedents or examples. And he presented us with numbers. And I'm hoping that he will bring these examples forward on his last meeting here, so that way we can know whether we got our money's worth. Whether he's right or wrong, it's important that the people we pay do some work and not just give out numbers. So I'm hoping when he comes back down, and that way I can receive his information, and I've received your information so far. And I assume that after his last presentation, you'll get a copy, and then you will be back. So that way this board can continue to make informed decisions on the pros and cons of both your presentations.
Okay, any other board member comments? Director Hanks.
Some of us doubt that the state can financially perform under the QSA contract. Probably under a lot of just regular budget item contracts. And following up from that, I would ask you this question. Did the state or any department of the state attempt to present a litigation settlement to the QSA JPA for mitigation costs after Judge Kennedy's decision?
Not that I'm aware of.
Okay, I'll leave that there. I got another question for you. What is our payment schedule for on-farm conservation?
Do you mean what's your schedule for paying or for getting? For paying to farmers?
Yeah.
Whatever you set.
Okay. So far, how many farmers and how much has been paid for conserving waters to the farmer?
Director Hanks, I'm not sure I'm the most knowledgeable of that. All I would have is the information that I got from your staff. We have been creating the conserved water on the exact ramp-up schedule. So for San Diego, each year it went 10,000, 20,000, 30,000, 40,000, 50,000, 50,000, 60,000, 70,000, 80,000, and this year I believe is 90. And there's been a price paid in each year. The first 5 years are in the contract. I just can't remember them. Then there was a arbitration over 2007. Actually, it wasn't. There was a settlement over 2007, 2008, and a price set for the current year. So we can look up that. Coachella was paying $50 an acre foot adjusted by inflation from 2003, I think, but maybe it was earlier than that. So it's probably now 60 something.
Yeah, it's close
and
to
that
70,
will continue to go up.
Yeah.
And then there's a jump to a higher number when they reach 53.
Well, we get numerous articles, mostly out of San Diego area, about how much the farmers are being paid for the water. And
farmers over here.
Yes. And as far as I know, the only farmers that's being paid are the ones that are being paid to follow the ground. There hasn't, those that have put in conservation measures, as far as I know of, there hasn't been any of them paid to date. But
I don't think that's right. I think that there are some farmers who put in conservation to help with the 88 agreement to transfer water to Met.
Let's see, Met transfer.
Yeah, and some of them have been paid.
Yeah, I'm talking about the QSA.
Okay. I believe, again, I'm not the source of any implementation program here.
Well,
but
what I'm getting at, there's a lot of cost, a lot of expense, and there's just not a whole lot of people getting rich off of this transfer. There's a lot of work ahead of us. There's a lot of planning. There's going to be some upfront expenditures, and from comments that were made earlier, it was like everybody's getting rich off of this thing. And
not by me. I've never said that.
No, I know you didn't, but it was
okay.
Okay. So what I'm getting at, this thing keeps going on, and I sponsored a resolution, and we passed it January 5th, and it was after the Judge Candy decision, and it was one of the whereases in the resolution said it is the clear intention of the IID board to preserve not only its rights but also its options, which would include filing a notice of appeal and seeking a stay of the final ruling in the QSA coordinated cases. I push that forward. Thought it was the right way to go, but I've always been concerned, and I've heard it from other board members, whether the state could or would step up to the plate when it came to these mitigation costs. And I was of the understanding, something that I just learned a couple of days ago, that the Department of Fish and Game, after the Judge Candy decision, that they came forward and made a settlement offer, or was intending to make a settlement offer to the QSA JPA, which hopefully then would have defined what they were agreeing to pay, and so we had some type of idea. It's an unknown to us. Whether you call it a fear factor or whatever, the fact that we don't know what those costs are going to be, and there is doubt in our mind whether they're going to step up to the plate. What are those costs? We would like to see that, at least a ballpark figure defined. In closed session, we got a little bit closer on it, but you might I'd just like for you to share with the public just kind of the range that we're looking at here. Just mitigation. I'm not talking about restoration.
Okay. First of all, let me just comment on the first half of your comment, which is I have no idea what the state Fish and Game was intending, but I'm unaware of what you just said, as I answered your earlier question. Second, what might mitigation cost? Well, it depends in part. The major drivers for QSA mitigation effects is the mix of dust mitigation and habitat creation. Okay, as the sea stops being a habitat, which is happening already. I think you can find tilapia in the mouths of the rivers and probably not anywhere else. But ultimately, they're projecting the salinity of the sea without the QSA even of being no longer able to support tilapia. How much replacement habitat will be part of the mitigation package? If your mitigation can be mostly air and very little habitat, you could probably come in at a number significantly less than the money being funded by the parties. If mitigation has to include lots of habitat, and what does habitat mean? Well, for fish-eating birds, if the habitat means building ponds that hold fish, that's much more expensive than just air mitigation. Or creating the marsh, which we're already in the process of doing, and that will continue. Then it'll be much more, and it could be, $500-600 million instead of the $387 million. What it will be is yet not determined, and partly will be influenced by our state board proceeding in terms of their vision, their meaning the state board, for whether the best place for birds to find fish remains in the Imperial Valley, or whether our habitat should be more terrestrial focused. I don't think there will be no ponds. I think we are willing and likely to have some, but the extent is unknown, so maybe that's the bookends. But that's just sort of my off-the-cuff opinion, and I don't think you should take a lot of comfort in that range from me. And I think your intent is to try to find out more from the people involved, which is probably not the lawyers.
Okay, that's the only question I have.
Okay, Director Desert, do you have any questions?
No, I'll wait to the end.
Okay, I'm going to pass for now. We'll see if. Well, the one thing that I wanted to stress, I know you said that the state have said that we've been moving the QSA forward. We voted on certain changes, and now we've let the state off the hook. So the state's no longer on the hook for the QSA mitigation, and I think you've explained that that's not the case.
That isn't so. The contract is intact.
Okay, very good. We'll open it up to the public. If anybody has any questions for Mr. Osias, would they step up here to the podium? And if you have a second mic, Mr. Garber, can you put your mic over there so Mr. Osias can participate if there's any questions? Go ahead. Step up to the podium and state your name for the record, and then go ahead and ask your questions.
Hello, Tom Sefton, Brawley, California. Couple of questions for Mr. Osias. You stated in your presentation when speaking of a decline in level in the Salton Sea and the increase in salinity and to what degree the QSA might contribute to that, you stated that ultimately those will wind up in the same place. How is it possible that if you reduce the inflow to the Salton Sea for a 70-year period, that there is no net effect, that there is no increase in the amount of playa is exposed, that there's no increase in the dust blowing off the sea? Is that possible?
So I have two answers. One is I've read the scientific reports and I've heard them explain them to both courts and the state board, and that's their opinion, so I've repeated it. And second, The QSA will speed up getting to the same spot. So if I created the impression it wouldn't, it will. It hasn't yet because replacement water is being put in. But ultimately, when that replacement water stops, either in 2014 or 2017, it'll get to its lower elevation faster with the QSA than it will get there without it. But they project that it'll get to the same spot. And if your question is why, and the answer is because the balance between inflow and evaporation on a very shallow bowl shrinks it to a size that is roughly the same. And somebody can run you through those numbers. I didn't create the model that predicts the elevation.
I've run those numbers, and the fact is that if you have a long-term reduction in inflow, the balance point between evaporation and water flowing in with less inflow means a lower level, more playa exposed, more dust blowing off the sea. Now, in the 2003 IID Environmental Impact Report, it does state that QSA could cause a lower level, could cause more dust blowing off the sea, and it uses a statement of overriding considerations, including IID making money off the transfers and various other things, to say that those factors will not be mitigated because they're too difficult and expensive to mitigate. Do you have a comment on that?
Yeah, it does say that. And it says that for a couple of reasons. One is that fighting about whether it will cause more and what that means versus overriding considerations is often a environmental review tool used to say whether it does or not, these things outweigh it. So we don't have to fight about whether it does or not. That's one response. Second is because it would cause the sea to go down faster, if you measure it in the term of the QSA, which is 45 years, not 70, in total volume, it is more. Its endpoint may be the same, but if it gets to the endpoint sooner, then you have more years of it, and so the volume is more.
Meaning more environmental damage over the next 45 years at least, which is pretty much a remaining lifetime for many of us in this room.
Okay, so, well, it's not 45 left, it's probably 38, but same point. The answer is yes, without mitigation, that would be the case. And so the state board approval and the adopted mitigation plan requires that the effect of the QSA's future acceleration on that demise has to be fully mitigated so that the only effect left is what would happen as if there were no QSA. And therefore, if the mitigation's done, it won't end up being more.
That's the big question. Will the mitigation be done?
That's the requirement of the state board, and that's why there's this money being created and spent to date to do it. And it's been done so far.
And it's highly arguable as to whether that $350 million is enough. You even said yourself just now, it may not be enough.
And if it's not, the state's supposed to pay the rest, and they have a contract to do it.
Yes, they do. And I can speak from personal experience being on a state contract that the state in recent years does delay payment on contractual obligations for years. And that's years of environmental damage and public health risk to the people of the Imperial Valley. So I hope those things would be taken into consideration. Also, I can speak from experience and say there are still pelicans out on the water eating tilapia from the sea as a whole. The fish population has not collapsed yet.
You agree it's predicted that it would with or without the QSA?
It will collapse. If there is no restoration undertaken, it will collapse eventually with or without the QSA. And with the QSA, it will collapse sooner. And with a sooner transfer of, more transfer of water to pay for some mitigation efforts, the fish population in the greater sea will collapse even that much sooner.
So I think you raise good points, and I would suggest that should there be a delay in the state's payment, it's not in the IID's best interest to suggest that IID will volunteer to pay in the meantime. In fact, I think you would want others to pay in the meantime, or you will stop the transfer until payment can occur because you're not allowed to transfer without the mitigation. So that's the strategy. Just in terms of a data point, I mean, I found a recent $8.5 million judgment where the appeal ended on March 24th, and the state appropriated the money by October 11th. So, there are a lot of examples maybe that go the other way.
I can give you a very different example.
Okay. So partly it depends on, I guess, how much they care.
Exactly. And right now, we do not know how much the state cares about the public health of people in the Imperial Valley. We're a long way from Sacramento.
Well, we're also a long way from having spent the $300 million.
Which is probably, as you stated yourself, not sufficient to do the job.
No, I didn't say probably.
Okay.
Very well. Possibly not sufficient to do the job.
Okay.
Okay, Tom, thank you. Mr. Benson. Oscar, there's other people in line here to talk.
You want to go ahead, Oscar?
Go ahead. No.
Mine is short.
He's going to jump on me.
No, mine is short. You know, Mr. Dumars?
I'm not Mr. Dumars.
Oh,
sorry. If I gave that impression, I want to correct it. I'm Mr. Osias.
Oh, okay, Mr. Osias.
I'm from California.
Okay. El vato loco. Mr. Osias, you know, I took philosophy, and I was a philosophy major. I got a minor in that, and I heard Mr. Dumars, and he did an inductive reasoning, and you did just the opposite, deductive reasoning. And you know, both of you obviously came with two different point of views, two opinions. I know when Mr. Dumars come here, he's going to give a different one where he said you were wrong, and then you get a chance, and we go on, and we're going to be paying you guys all kinds of money. And that's up to the board. My question is, you mentioned something, and you just alluded to it briefly, where you said, if there's no mitigation, there's not going to be payment. It seems to me you were suggesting at some point, when can we stop paying because there's no mitigation so that the water stops? Farmers aren't making money off of it. When do you suggest that IID stops that so that the water transfer stops?
IID cannot stop the transfer while the parties are performing, and it shouldn't want to. It's got a contract that's being performed to date, and so I think it would be foolish to breach it.
But what did you mean by that then?
Well, if there's no money to pay for mitigation, which is a long time in the future and may not ever occur, that would be the time to decide.
Thank you.
So that's a long way off.
The last point that I want to make, I remember Mr. Maloney during the water transfer, and Mike Morgan basically said that when we were going through the environmental impact report, a lot of the issues were not mitigated. And we're finding that now. You just mentioned that. I remember Mike Morgan and his attorney essentially said that they had mitigated the Indian tribes, what the water transfer meant, not only for the Indian tribes, but also for Mexico, and also for the animals. And none of that was mitigated. Yet, Mr. Bruce Kuhn voted in favor of the water transfer. I'm glad, Estela, you didn't vote for it. I'm glad you didn't. But I remember Mike Morgan. As I'm here, Mike, you were absolutely right. And so was Maloney. And they said you were crazy because you were suing IID. This gentleman just tells me there's a bunch of lawsuits, and I'm glad you continue to sue the IID. Some of them are crooks. Thank you.
Okay, Mr. Benson.
I had a question on the San Diego, a couple questions, but the San Diego transfer, where's the water coming from? My understanding is that they had to fallow in order to put it into the sea. So we're going to have to fallow in order to transfer it to San Diego. Is that true?
So the transfer so far to San Diego has come from fallowing, and the mitigation water that that I identified that we've asked to cut off is also currently coming from fallowing.
Okay, and then you had a schedule that had different rates. I think it was $115 an acre foot for the first, and then it scaled up to $132 an acre foot for the last. On what we were getting paid from San Diego for the transfer, or is that in excess of what?
So are you talking about the schedule that was on the screen?
Yeah.
No, that's payment for mitigation water,
right?
And that's not in a per acre foot. Those are millions of dollars But
then
lump
it
sum.
had 45,000.
That's how much water per year
Right.
for that total price.
Okay,
It
so
wasn't a price per acre.
I saw 45,000 acre feet at 5.2 million. That works out to $115 per acre foot.
All right, so if you did the math.
Okay, so we're going backwards if now the board approved of paying $125 for fallowing water to farmers.
Well, San Diego is not paying that. That's the mitigation water cost. San Diego is paying for its $90,491.
Oh, so
an acre foot.
they will pay the higher number.
Yeah.
Okay. That was one question. And then I had heard that escalators were dropped as part of that agreement, and I don't understand. The escalators are part of the original QSA, but I didn't hear it in your discussion. Is that the case?
Well, I was talking about mitigation water. There's no escalator in the mitigation water other than the price schedule that I put up there. In other
Okay.
words, that's a fixed price per year.
Okay.
Okay. There are escalators in the transfer prices. Both Coachella has an escalator. I see Mr. Horn. He knows all about this. There's an escalator to Coachella. I'm waiting for the day that I'm allowed to. And there's an escalator from Coachella. There's an escalator from San Diego. Different kinds of escalators, and there's not for the mitigation water other than that
Okay.
total price.
And those all stay in place with the QSA and any of this new state board?
The state board is about changing the mitigation water schedule and redirecting the money.
Okay. All right.
It's not about the QSA contract with San Diego or Coachella or Metropolitan.
Okay. And then what you talk about that the IED's forced to follow the schedule of fallowing or conserve. As chairman of the on-farm, or not on-farm, but Water Conservation Advisory Board, we've been waiting for the on-farm to come, and Jesse's brought it to us, but it's one of those programs that it's almost too complicated to figure out because it wasn't created by a farmer, and we're still waiting for something to see, like a contract where we can implement it. Supposedly in June we're going to have those, but also in June we're supposed to sign up. The question is, if farmers don't conserve water, or if they don't sign up for fallowing, then the IED won't have the water to be able to transfer. Is that correct?
In large part, yes.
Okay.
The IID needs to acquire a large portion of its transfer commitment from on-farm conservation.
Okay.
That's both correct from a economic and volume perspective,
Right.
and also from a pragmatic and contract perspective.
So the system conservation is the only way out, but that maxes out under 100,000 acre feet or something.
That's correct.
Okay. And then I would just recommend when Dumars come, I don't know if Osias and Dumars can be in the same room together since they're not allowed to talk to each other, but if we could have a little...
We're often confused because we've never been seen together.
Exactly. But, I mean, rather than having this tit for tat one meeting after the next, to have them talk about the issues together, it would be more beneficial for us so that we can hear the rebuttal back and forth as opposed to a, well, he said, she said type argument. The last thing is, at this point, I'm a little confused, like the rest of the public. How do we not know what the costs for either mitigation or restoration and which decision we're making? Because it seems like 2003 was a long time ago. There's been a lot of money spent. And Jim Hanks made a statement that no one's getting rich. I think just the lawyers on both sides. No offense, sorry.
I'm not offended.
And I guess that my real question is, as a ratepayer, what have we paid for? What should we know at this point? What are we going to have to pay for again in order to study it again? It seems like we keep studying mitigations or restorations, air quality or fish, and there's really not a plan that anyone's jumped behind. Is it the IID's responsibility to create that plan, or is it the state's responsibility, or is it the JPA's responsibility?
So there's two parts to your question that are linked, much like they are in reality. Conservation of water and mitigation.
Right.
Okay. It is the IID's responsibility to craft a water conservation plan. And as you noted, it has to include farmers practically. Mm-hmm. And so there has been a lot of effort, I believe, in trying to accomplish that. There are very few, but there are a few restrictions on water conservation. So 300,000 total ultimately has to be created. We're currently at 110, I think.
Right.
When you're at 300, at least 130 has to come from on-farm. Practically, it may be much higher than that, but the contract says at least 130.
So if you assume the most on farm you'd get is an acre foot off of each acre, you're saying 150,000 acres, so that's a third of the valley has to sign up.
Probably, but
Okay.
You know that math better than me. I'm just telling you what the contract. The contract says at least 130 of the 300 has to come from on farm. Contract also says, in its current form, the 200 at ramp up to San Diego can't come from fallowing.
Right.
Okay, that's it. Total contract language about conservation of water.
Could it ever roll into a permanent fallowing situation where we're not getting it from on farm, but yet you have to fallow more ground in order to get there?
You could do a fallowing program to create transfer water for Coachella that could last as long as the QSA.
Okay.
Yeah, that's allowed, not required.
Okay.
That's your board's decision.
Right.
Okay, now the second question about predicting environmental impacts. As we heard from the first question, there's been a fair amount of studies about predicting when certain impacts will occur on different species. Also, how much of the soil will actually emit dust. It's not possible to predict exactly what will happen for a variety of reasons. It's like predicting the economy, or like predicting the weather, although that's more of a short-term prediction. I think they're pretty confident that there'll be a summer and a winter next year. And they're pretty confident that some soil will cause dust when the wind blows and that they'll have to mitigate that. How much is the question. So studies to date say that anywhere from, Bruce will correct me, but I think it's like 35 to 70% of the soil exposed might create dust. Well, that's a big swing, right?
It's still a big impact either way, though.
Well,
that's a lot of soil that we're talking about.
Yeah, but if the cost to prevent dust blowing isn't very expensive, okay, if you double it, it's twice as expensive. You double the area. So if you start adding up the ranges of impacts, and because you're predicting the future, and because people aren't actually sure what the future weather will be, or what the future farming will be, if more water were going to the sea in the future from farming than currently, then the impact would be less.
Sure.
And if less, not caused by the QSA, it could be more. And so the farther out you go in the future in predicting, the harder it is to know precisely what the impact is, and therefore you can't know precisely what mitigation will cost. Second, as we know from our own lifetimes, when you're talking, and I think somebody made a comment about 30 or 40 years as your life expectancy. I hope for a lot of you that's longer than that, but that'd be great for me. If you see the pace of innovation and change, what might be difficult or expensive today as a tool could become very cheap in the future, depending upon new technology, new science. And so the QSA does not dictate how you will mitigate in the year 2025 or the year 2035 or the last year 2047. It doesn't even identify specifically what the impacts will be in those years because they're not here yet and we're not certain. So what's been adopted in the mitigation plan is called adaptive management. You study the impacts today, you test mitigation tools, and you implement them as needed when things show up in the environment that need to be mitigated. So the state board requires mitigation, but doesn't require you to mitigate before the impact shows up, only when the impact shows up, only to prevent the impact.
Right.
So there's a group of scientists and biologists that figure out what the impacts are, what they've learned from them, how they can project them out for next year, which they absolutely have to do, 5 years, which is a reasonable time period for planning, and then the farther they go beyond that, the more fuzzy it gets. And so it's not possible to say what will have to be done and why, and therefore how you'll mitigate it, and at what cost 25 years from now or 30 years from now.
Right.
And that's why there's no mitigation plan that's specific that goes out that far.
I understand. You talk about the QSA only being a 45-year contract, is that right?
That's correct.
Isn't there an extension to the QSA that rolls it automatically, though?
No.
How does the extension work when it extends?
Both IID and San Diego have to choose to renew it for another 30 years.
Okay, so they have
So
to
if
agree.
either one doesn't, it doesn't renew.
Okay. Thank you for coming.
Thank you, Mr. Benson. Anybody else? Mr. Manueli? No? Mr. Kuhn?
Bruce, it's nice to see you again. I haven't seen you in a long time.
In a while. This is going to be a long meeting for you people. Bruce Kuhn, 1240 Drew Road. I have just part of the misunderstanding that's going on out here, and it's has to do with the amendments of, I think it was 2010. Are you familiar with those, David?
On price?
Yes.
Yes.
Okay.
I didn't bring any materials, so I'll do it from memory.
There you go. You've been doing a pretty good job of that all day. Is the price for water now the same as it was in 03? Through the back years.
I guess I should use the mic, though I probably don't need it. The price isn't the same, nor is the price formula the same. I don't know which one you were asking about. You remember we started in 2003, it was pegged at 250. And today it's
it was pegged at
490.
It was pegged at 250 with escalators in the back years.
Yeah, and a declining discount and a bunch of other stuff.
Okay.
So the
now-
formula is different, if that's what you're asking about, and the price is also different. You just asked me about the price. I didn't know what you meant.
And the amount that they're going to get, that we will receive for water, is it more or less than it was going to be on the original formula? I mean,
For the life of the deal?
Yes.
It's in the same range. But again, you're predicting the future, and so all we could do is forecast ranges of outcomes, and it's close to being the same.
There's something said about the price flattens out at, I believe, $600 after what year? And then in
20. I see I didn't bring my schedule. Is Greg here? 2017?
2015. Beginning in 2016, the escalators kick in.
What's that?
2015, the price is $624 an acre foot, and then beginning in 2016, there is a escalator that drives the price.
Now
wait, that's not quite right.
That's true.
Okay, so let me see if I can. I was just remembering the year. So 2016 is when the inflation escalator kicks in.
Yes.
Okay, so the price right now steps up to a number that's in the amendment you asked about, and then after that date, it increases by an inflation index until 2034, and then in 2035, it goes back to a base contract price formula as adjusted by market to 2047.
And that is the number I'm seeing is $600. It just flat out
No, it's between 20, if I'm going to get the date wrong, fix me, but between 2016 and 2034, it's 600 adjusted by inflation.
Okay, by inflation, but there are no more escalators beyond that. That would,
For that period of time, that's right. Okay.
Then this thing has been changed
Well,
substantially.
I did say the formula had been changed.
But I'm not faulting you. I'm just saying
but
it's been changed, and it's been changed substantially from what we had in there. We had escalators in the back years that went up all the way through
well,
the back
and they
years.
come back in 2035. Okay.
When the deal's almost done.
Right. So maybe your question to me could be, Bruce, if you wish, is if I think it's roughly the same, and it's got this period of where it's only increasing by inflation, why is it roughly the same?
Because if it's just by the inflationary amount, then we are not getting the advantage of the entire escalators that we had in there in the original deal. The escalators in the original deal were substantially more than just the inflation.
Yes, they were. And what we did is we moved some of the money forward that was projected to come later, and then did a present value analysis that became roughly the same.
But the overall, at the end, it's going to be substantially less, David. I mean,
no, I don't think so.
I truly, then I respectfully disagree. As you read it, it shows it's going to be substantially less, and I just don't think you didn't do it. I mean,
no, that's all right.
But anyway, it's been done, and I really feel it's not in our best interest.
Yeah, don't tell him that's one of his campaign deals. So
don't tell him what.
Anyway, go ahead.
I don't want to be in any campaign.
I think what he means is, don't tell the people something happened here.
No, that isn't what I meant. That isn't what I meant, Bruce.
Oh,
Don't rain on your parade, buddy.
Mr. Osias, what
That's
is
part of the formula change.
The formula that they're talking about?
Yeah.
They had the shortage
premium.
Shortage premium. That was a word.
Yep.
That was removed until 2034. What was the estimated value of projected value of that shortage premium?
I don't have that present value number in my head, Director Hanks. So it would have been from 2017 to 2016, whatever, to 2017, because it had already been eliminated from years 1 through 2017. So it would be 2018 to 2034. How often and what extent would the shortages be? And then you reduce that to present value. And I can't remember. There was a probability analysis of some kind that converted that into a dollar. Okay, and also there was and then afterwards, of course, it's back. So that would be a wash because it comes back in 2035.
Yeah, the spreadsheet that I looked at in 2034, when it comes back, the projection started around $7.5 million and escalated up to $10 million. That was the projection. You know, unless there's a shortage declared, then
right. And it also the amount of money varies with the place of the shortage, the extent of the shortage, and the duration of the shortage. So much like environmental, and much more like Oscar's predicting the weather, predicting river shortages, and it depends. Some of it's Colorado River, some of it's the Sacramento River, and some of it's just rationing declarations in San Diego, even if there's no river shortages.
if that premium is triggered, say 2034, by formula, what is the increase?
All right, so I'm doing this from memory. So cut me some slack, because I have it. I have it actual that I didn't bring that file. My memory is that if it's a shortage on the Colorado River, it's 20% premium, and if it's a shortage on the Sacramento River, it's 5%, and if it's rationing in San Diego, not tied to a river flow, just rationing. Depending on the degree of rationing, it can range. If they ration, I think at the high end, it's 100% premium, so it doubles your price, but they have to ration by cutting every water user back by more than 30%. Okay. And it's during the period, so if that was a 3-month problem, it would be only for 3 months. If they ration 10%, I think it drops all the way to the premium drops to 25 or 30. I mean, it's a slope. So it depends on how serious their rationing is and how long it lasts. It was, I will say, as you know, it wasn't in effect for the first 15 years because it was thought to be too speculative and was traded, frankly, by the farmers in the negotiation for more certainty on the front end price for years 1 through 15, which takes us to 2017. So this amendment took it from 2017 to 2034.
Yeah, we're working on an audit on that, too.
Yeah. No, I was
think
asked to
that-
give background information and did just
Right.
last week, I think.
That's going to be presented to the board within 30 days.
Okay.
Yeah, I think Betty's working on
If
that.
I can get more information to you, I will. I'm sorry I don't remember it all off the
Yeah,
top
no,
of my head.
that needs to come back to the board and make it known what the situation is. Anybody else have any public comments for Mr. Osias? Because we're going to move on into the next item, and then he needs to get on the road.
I have a question. Mr. Osias, I've got a question in regards to the QSA and protecting our water rights. Now, with the QSA, we've been clear from approach on the 417 process. Is that correct? Yes. And we've been protected, or we haven't been come after for additional waters. That's what the QSA is affording us for additional transfers.
We haven't been accused of wasting.
We haven't been accused of wasting.
So that's one protection. And I guess your question is, have we been approached for more transfers? I think people have asked if you'd be interested,
Yeah.
but no pressure if that's what.
Yeah, but
Well, we have an annual 417 meeting that takes about 15 minutes. Oh, an hour. Okay. We used to have them that produced, like the one in 2002. You're wasting water results.
yeah. Now the Bass Brothers, when they bought the ground, they wanted to transfer the water, privatize the water rights, and transfer it, and they were not able to do that.
Is that a question?
Yeah, that's a question.
I don't know what they wanted when they bought the land.
But-
I wasn't involved in that. But a farmer can't transfer water to San Diego just because they own the land.
A farmer can't transfer water to the land. That's correct. And then the IID bought the same ground, and then they were contemplating transferring the water off of that same ground that they bought, or the Bass Brothers originally bought.
They bought it from U.S. Filters.
They bought it, yeah, went to U.S. Filter to Vivendi, and then it went to the IID. Was the trail. Now, the IID, and I wasn't here on the board at the time, but they were
I didn't work on that either, but obviously I've read
No,
it.
I'm not talking about who worked on it. I'm just talking about being able to transfer the water rights. The IID, they could have sold the water off of the ground because they hold the water rights in trust.
No, that's the wrong reason.
That's the wrong reason.
They could have transferred the water off of the land they own for the same reason they can transfer water off of land that someone else has owned that's conserved under the QSA.
Okay. So back to what you said earlier about a private farmer cannot privatize the water rights and transfer and sell them. The QSA does not allow that, and the QSA doesn't change that. The IID holds those water rights in trust, correct?
The QSA does change some things about transfers, but not the district's, not the nature of the water rights.
Not the nature of the water rights.
Right.
Because there has been some discussion about the QSA. There's all this discussion and arguments about what the QSA affords us and gives us.
Well, and it's fair comment for me to pause for just a minute and say, our belief, my belief as one of your lawyers, others of your lawyers' beliefs, and I think your board's belief and general counsel's belief are not always identical to, say, Metropolitan's belief or the Bureau's belief. So what the QSA clearly does by contract is avoid us having to fight about whether IID can transfer conserved water by having everybody agree to it under the terms of the QSA. So that's not a change in the water right. That's just an agreement to stand down and allow transfers for the QSA.
But as you said earlier, a private farm or a private property owner
It didn't change that at all.
Didn't change that. And do you foresee that ever changing in the future? I don't, with the QSA or no, without a QSA.
Yeah,
I
I'm
don't.
trying to imagine what would cause that to change.
The IID will always exist. The IID holds the water rights in trust, and the IIDs will be the gatekeeper on these transfers.
Well, that's not, I guess, foreseeing and possibility. I mean, could the IID let somebody else do it?
Mm-hmm.
That's an interesting question. Would the IID let someone else do it is a different question
Depends who's on the board.
than whether it could,
Mm-hmm.
right? And I don't think I'd want to speculate in public session about either of those questions.
Yeah. Thank you.
Okay. Okay, David, thank you very much for your time. And then we need you to just stay here for the next item, which is a review of draft temporary land conversion following policy.
Mr. Haddam has to drive me back, and since he went a little fast on the way here, I'm sure he's not going to go a little fast
I think
on the
they
way
just
back.
wanted
We
you
need
to
be
sit in
careful.
on this one, though. So Tina's going to
Well,
take
David,
this.
before you leave, I want to thank you for coming by today and also giving your view of the QSA and the problems and the perceived problems and so forth. It's always good to have the facts presented to the public, and I appreciate you being here.
Thank you. My pleasure.
What I bring forth today is an information item for board consideration. We were tasked earlier, I guess last month, to develop a policy that looked at, in particular, the solar projects that are developing and find ways to maximize utilizing the water resources that would have been used on those properties had they not been entering into a type of program that converted the use of land from agriculture to another style of use. We came before you April 3rd and presented some different definitions of fallowing and highlighted Water Code 1013, which was a piece of legislation created for the QSA, but essentially it expanded the terms for the duration of the QSA of fallowing and enlarged it so it wasn't just a temporary type of project, and also it expanded the nature of that as being conducive to a project such as solar or another change in use type of project. So tearing off of that, you have in your board folder essentially the same information that was presented, just in a little bit more policy-oriented form, that outlines the nature of the policy that would essentially develop a fallowing program that would target these change in land uses. A couple caveats that we talked about before: this has to occur within the duration of the QSA. That's one of the caveats. And once that water would be designated as conserved water, it's limited in its purpose. It could be used for transfer purposes or environmental mitigation. There's been some concern raised, well, couldn't we use it in valley? That's a use that's currently allowed. It's a water management decision that the board currently makes. If certain properties change their use and water isn't necessary as it has been historically, that water is then available for other purposes. This wouldn't preclude this, but this would allow additional management opportunities if that water were designated as conserved water for use for transfer purposes or for mitigation. So again, it doesn't preclude the use of that water in valley, but it expands opportunities and basically gives us some more management and water resource flexibility when we make decisions on an annual basis about how water should be delivered and how we meet our transfer obligations. Currently, the only transfer it would qualify for would be the San Diego transfer during the fallowing term, which is the first 15 years, or to meet the Coachella obligations. This might allow you to implement different projects and cheaper projects. It might provide a cost savings to the district. It may be that in certain years you want to use that water to meet high demands in a year like this where we have high agricultural demands, or it may be in the future that you want to designate that for use for industrial projects that might develop that have higher water demands. But what it does is provide that flexibility that we don't currently have. This policy does not envision any payment to those landowners because they're making land use decisions on those projects absent IID. In addition, they're already bypassing the electrical system, at least in the projects we're seeing, and we're not receiving sufficient revenues from the limited sale of water that will occur to, in essence, maintain those facilities over the longer term. The other caveat in this policy is that these lands would have to obligate themselves to go back to ag when that project ended. So if you have any questions, I can try to answer those or go into more detail.
there any board questions for Tina?
No, I read the draft document. It seems pretty concise and kind of covers all the areas of concern that the board had.
And I will go back and expand on the fact that it can still be used for in-valley purposes. Some people felt that this was too specific as to the transfer requirement or the environmental mitigation. Again, it doesn't preclude that from being used in-valley for a beneficial purpose, but that's a use that's currently allowed anyways.
And the board doesn't understand that there's going to have to be some consultation with the county on this. That's required by that statute. And we have some environmental documents that we have to prepare that are referenced in here in order to finalize this for board action.
And I think we talked about that April 3rd, that it requires...
For information only
Right, it
for
requires
today.
findings by the county that there's no environmental impacts. And currently the county is the CEQA lead agency on these projects and is making those findings, and they're actually written into the CUP.
So if the board directed us to move forward, I don't know exactly the date we bring it back. It's going to depend on, I'm looking at Brad, but I don't know that it's going to be Brad.
I actually talked to Brad about this last week, so...
He said, no problem, whatever you need, just show me where to sign.
But the resolution has a whole bunch of whereases, but it's essentially laying out the legal basis and the CEQA analysis. It makes findings that for the projects already approved, the CUP language is clear that the mitigation has already occurred and that those would occur in the future on a project-by-project basis. So it's essentially dotting the I's and crossing the T's for purposes of this.
Okay, any board member comments, and then I'll turn it over to the public.
Yeah, Tina, I'd like to thank all your work on that, and we've had some other conversations about it. I'll visit with you later in the week.
Sure.
This will be coming. We're dark next week, so we'll have
Yeah, the earliest it would be back is May 1st, and depending on if I receive comments that need additional clarification.
Maybe a week or so later.
Yeah, I'll be visiting with you on it.
Sure.
Thank you, Tina.
Any other board member comments?
Yeah, we discussed this in closed session, and it was pretty thorough, and there were some things covered that were not covered now that the public needs to know. The classification of fallowing of this solar, will that be classified as system or on-farm conservation?
I would say it's on farm. It's occurring on a field.
Is it designated for Coachella Valley Water or San Diego?
It could not be used for San Diego except for the first 15-year period unless there was a waiver on the fallowing requirement or fallowing restriction that's in the San Diego contract. The designation is purely a bookkeeping matter. It would be, a consultation process to see what the IID demands were that year, what the transfer obligations were, and how we were meeting those commitments. So it gives us a flexibility tool that we don't currently have.
Okay. What is the classification, price, and quantity for reasonable and beneficial water at the site? Is it sufficiently priced to cover all costs, including drain, M&O?
The conserved water? I don't understand the question.
Yeah. What is the price that we're going to place for water going to the solar?
The water that will be issued for the project is under the interim water supply policy, and that's a tiered pricing schedule that starts off at approximately $250 an acre foot and then goes up. That is specifically for the water supply development fee, which is the cost of keeping the ag community whole as far as impacts on their water use. The delivery charge is $85 an acre foot.
But Director Hanks, that price does not include maintenance of the drainage system. However, coincidentally, in the process of providing crossing and encroachment permits for those developers, we are requiring them to mitigate the drainage impact caused by the significantly reduced collections of water fees, if that's your question. I think it is.
Yeah, I'm concerned about when they order water. Are they going to be required to have infrastructure for holding purposes?
My understanding is the county has a permit requirement that's either a pond or a water tank for fire suppression purposes. These projects have explained to me that they will be building water treatment plants. They need to treat the water to a higher quality. In some cases, I know they're also benchmarking other water costs from treatment facilities that's already treated, and they would truck to the site. So we've not yet issued any contracts. The requests range generally about 15 to 20 acre feet for these projects for just operational purposes.
So we're not, it doesn't appear that there's going to be a problem with spills or... they'll have some type of holding.
Yeah, one of the requirements of the IWSP is that they provide a water supply report that explains the BMPs that they utilize. For these types of projects, because the water demands is so small, it's generally a meter. Plus, they're going to be treating all the water. So from a treatment standpoint, that's where the bulk of their cost is. They only treat what they need.
Director Hanks, I know that some of these folks may have some type of cover crop for dust mitigation, and some of these other folks are talking about perhaps a conservancy easement to address some of the, to address some of the complaints about the removal of ag ground. And we sort of have a mechanism under the IWSP. You want to explain that?
Right. Only one company of the developers I've spoken with have indicated any desire to use water other than operational water, which is 15 to 20 acre feet generally for the large-scale projects. There's been one company that has inquired about cover crop water because that is potentially an option for dust suppression, as would be graveling or chemical application or something else. We have indicated to them that that's not the type of water that would be available under the IWSP, and it's really high prices, so they don't particularly want to do that, that we would make that water available in their contract on an as-needed basis in years where it's there. In years where we were under an allocation or there were limitations, that water would go first and foremost to the farmers who are going to produce a crop and harvest, and not for weed control purposes. And so they wouldn't have to pay the high IWSP price, but they would only get the water when it's available.
They would still pay the industrial rate because
For
they're
delivery.
really not using the water for true agricultural purposes.
And they've all
I think
seemed
we've
satisfied.
discussed that before.
Yeah, they've seemed satisfied with that. I don't know that we'll actually see that ever occur with the cover crop. It was just more the inquiry.
This draft is heavily geared towards transfer, water for transfer and so forth. I'm very concerned. What happens, say, if we have a failed QSA for whatever reason, or these LLCs go under?
The problem is the only
What
reason.
happens to the water? What,
Well, the
what
legis-
are we making to the landowners in the event that they say, hey, pull that thing out of there, I'm going to go back to farming, and have we overcommitted ourselves as far as the water?
What the language will say, it's on page 38 of the agenda, 6 point. It basically says, it's not super firm language. It says you're eligible to receive water in the future under whatever rules are in place at that time. That would be similar to what folks would envision now when they pay their water availability. It's with the understanding in the future the water's available under whatever rules this board or a future board chooses to implement. So it won't go beyond that.
Okay, I would just caution the board that we move slowly on this, that we want to make sure that we're not overcommitting, that we have a place for this water to go, and as much flexibility, that's fine, that's great.
But the problem is the QSA connection is unavoidable. The only reason that you can have fallowing on such a long term and call it fallowing is Water Code Section 1013. And that was created as part of the QSA implementation. The QSA does not allow us to do this, but a statute that was created for the QSA does during the life of the QSA. And that's the statute that changes fallowing from a short-term temporary process to, amazingly, something that can go on for 30 years.
Well, one of my big concerns has been with the water going to Coachella, is whether we could conserve it for the price that we were getting. This offers some relief there.
Correct. And if you'll notice section 6.3, it does specifically note that IID shall have total and absolute control over any such conserved water. That means you all get to decide where it goes. Does it stay here? Do we use it to meet a current obligation and reroute some of that other water for storage purposes or payback? So that's when I talk about flexibility. It allows us to do things that we can't currently do.
There are a couple of considerations that that the board is aware of, but the public might not be. The references in here are fairly vague to establishing a baseline. There's talk of a historical baseline. There's work to do there. The board is naturally interested in seeing what form the agreement between the landowner and IID will take. But the board does need to be aware that to this point, the projects that are farthest along in the Mount Signal area, the ones that bypass us, they have not. None of those projects have entered into a water supply agreement with IID. Is that right?
Right. We've issued no contracts. There are 2 that would like to get going.
Well, you know, I understand that it's a different quantity of water that they need, but we've had other developers, other types of energy, where their whole projects was dependent upon them having a water source. And this won't be the end of, I'm sure, of solar projects coming forward. But these are agreements that need to be in place. The county needs to recognize that these are in place before they start permitting and authorizing land use changes. You know, we got this thing bass backwards.
And we've had some preliminary discussions with a few staff from the county, and they indicated a willingness to write things into the CUP that would facilitate these type of agreements. So if the board were to adopt a policy, we would then work with the county to get this language put in the CUPs, so it's a little more upfront and not having to do things in this manner.
I just want to make sure that the water rights portion is taken care of. Okay.
Any other board questions for Tina? Any questions from the public? Did Tom, you're back there? You got a question?
Tom Sefton. First question, Tina. In the now therefore section of the resolution 2A, say environmental compliance report attached to the resolution as attachment B?
No, that hasn't been generated yet.
Is that going to be available to the public?
Yeah, before the board takes action.
We can't generate that report till we have a more definitive policy. So we're bringing forth the policy for information. We'll see any concerns that need to be adjusted, and then we'll draft that final document. But it's just going to cite the information that is pretty much available in the existing IWSP, the transfer documents, and then the county permitting process.
I would ask that we consult with Mr. Carter on this, particularly regarding the impacts not only of this, but also on available water fees that we're charging, and make sure that we're covered there. I think we have a long-term problem developing.
Yes, sir.
Try to get that resolved.
Second question, also in the section of the resolution, item 4, the last section says, the water conserved from such temporary removal of such land from agriculture shall be determined by IID staff based on historical data as outlined in recital M, and shall be available for transfer or other use under the QSA and its related agreements, or otherwise as allowed by law. It would seem to a layperson that last statement might allow for sale and transfer of water over and above QSA allocations. Would you care to comment on that?
The 1030 specifically limits this water for transfer purposes. If we call it a fallowing program designated as conserved water, it's specifically limited for transfer purposes or environmental purposes. That being said, the district has the right to use water for any beneficial use within its service area. That's what that's talking about. So to the extent that the district issues a water supply agreement to a bottling plant that uses water, we could use this water. To the extent that the farmers have a great ag market and they need supplemental supplies, this could be used for that purpose. So when it says lawful uses, it's not a conspiracy theory. It's just saying that there's other things we can currently use water for, and that we can use water for those purposes.
Remember, we're using that water now. We're just giving it a new designation to give it an additional use, but it's still part of our water supply.
It has been discussed today that water conserved by this method could be sold to Coachella, for example. And that's fairly seductive because you're selling water to a farm right now at $20 an acre foot. You shut down that farm, now you're selling it to Coachella at $100 an acre foot, 5 times the price. That's easy money, and easy money is very seductive, and I wonder at what point does this stop? How many farms do you shut down just to make money? And is there a mechanism to limit that?
I don't think that's what was said.
We're not shutting down farms.
I think actually, Tom, that what we're suggesting is that Coachella piece of the water transfer, in part, might be fulfilled through parlaying this water instead of.
So the water you would have transferred to Coachella is now available for other uses because you're using this water. It's all fungible. It's all water.
I understand. What I don't see anywhere in this resolution is any specific statement that says the transfers achieved through this method would be limited to what's now in the QSA. I don't see anything in here that says there would not be additional transfers. That would be my concern.
I think we could fix that.
Yeah, hey, Tom, let me make a comment. Tom, the farms are not being shut down. They're shutting the farms down because they're getting $800 an acre rent for solar projects, and they choose to shut their own farms down because they're making more money than they would through the farming method.
I think
That's their choice as a landowner.
The initial decision.
That's a landowner's choice. It's private property right. It deals with land planning at the county. It's not an ID issue.
I would offer two comments on this. One is that 1013 limits for the term of the QSA, so that is the limiting factor. Additionally, IID is not providing any compensation for this, so these are not incentivizing conversion of land projects. These are attempting to make the district whole on those projects.
Any other public comments? Charlene?
Good afternoon, Charlene Wardlow from Reno, Nevada. I actually was very hopeful about this whole program, but I have a couple questions. If you, for example, free up water on, say, 4,000 acres from one of the large solar projects that uses maybe 5 acre feet, that's 20,000, and let's just say that they use probably more than they do based on Tina's numbers, that you free up basically 16,000 acre feet of water. It sounds like that's supposed to be added to the interim water supply policy water, which is currently, that water right now is at $20 an acre foot that farmer had been paying. But my understanding was that when the IRWMP was completed, the interim water supply policy would go away. So, you know, is it possible that, I was hoping for a lower price through this, I'm not hearing that this lower priced water that is coming off these solar farms at $20 an acre foot can reduce that IWSP price that's $400-ish an acre foot to help us get our projects developed here. That I just don't see the IWSP going on away, which is I thought what was supposed to happen when the final plan was done this summer. And then can it be used to dilute the price? Because you have an opportunity to rewrite the pricing that's in the IWSP right now and get us economic water for our projects.
I think the intent to link this to the IWSP was to provide the district with those opportunities. It could be used for that purpose. It could be used to meet overrun purposes. It could, I mean, you just have the flexibility and tools to make those decisions. I don't think the district has made those decisions yet. The IWSP was supposed to be a bridge between the development of a larger scale plan and the implementation of a project to provide those supplemental waters or conserved waters to offset those. It will depend on the projects identified in those projects and the costs associated with those for the board to determine the course of action, whether that be implementing a desal plant or recycling plant, utilizing this type of a land conversion policy. But those will all be decisions for the board in the future.
I'd like to say that I share your concern, as we have spoken before, that I felt that the ag rate of $20 and then charging industrial $400 an acre foot was way, the difference was way too much. And because you're only going to use like 3% of the water is for industrial use and municipalities and home use. So I think we should come up with a better price to encourage economic development. I mentioned this before as a board member, but didn't get the support of the board.
Yeah, I just felt in reading this that it wasn't clear what the ultimate price was going to be, and based on what I heard today, it sounds like the pricing is going to be exactly the same as the IWSP, but getting added to the 25,000 acre feet, which currently only 3 contracts have been let on that 25,000 acre feet in, 3 years. So I just see an opportunity to change something that hasn't been working. with the solar farms coming in to help facilitate other industries in the valley that need water and have the same 30-year CUP as the solar farms.
I understand what you're saying. Yeah.
Okay.
Intended to modify the IWSP at this point in time. It just provides a management tool that could be used in the future to modify it, but currently it's just to provide an augmentation opportunity.
Okay, if there's no further questions, we're going to take a quick 5-minute break before we move on to the other items. Okay, Joel, you're going to be up on the number 5 energy update on San Juan coal mine reclamation, page 44.
Just what time are the Lakers starting tonight?
7:30.
7:30. We're good.
Yeah.
We're good. Just wanted to give an informational update for the board. Mr. President, are you ready?
Yes, go ahead.
Okay. Informational update on the board, just some background information. San Juan, recall, it's a 4-unit, 1,800 roughly megawatt coal-fired power plant. It's in the Four Corners area of the United States, just outside of Farmington, New Mexico. The Southern California Public Power Authority, of which we are members, is a 41.8% owner in Unit 3. And then the IID of that 41.8%, we are a 51% contract rights, which is roughly 104 megawatts. And we have a power purchase agreement that runs until 2022. The San Juan Coal Company supplies the coal from a nearby mine, underground mine. And then the point that we want to jump into is just in regards to the reclamation of the mine itself that runs out to about 2050. Under the agreement with the underground coal sales agreement that was entered into, I believe it was in 2001, around that time frame, the operators are essentially required to compensate the coal company for the reclamation and, as you can read, the related liabilities, obligations, and costs associated with reclaiming that mine. We're supposed to make arrangements that are acceptable to San Juan Coal Company to assure that all the obligations will be met, and that we would come up with either bonding or some kind of funding of a secure method to make sure that that happens. The essence of this presentation is that we are moving forward under the obligations of this coal sales agreement to make sure that we are accruing the money, setting this aside, and being able to fulfill our obligations under that agreement. There's two parts to this. There's a funding agreement, the Mine and Reclamation and Trust Funds funding agreement. So it really just sets up the requirements for the participants to establish an irrevocable trust. And these are individual trusts. It's not a joint trust arrangement, so each party is funding this individually. This was supposed to have been entered into in 2007, so obviously we're a little bit behind schedule. The funding methodology and the amounts, we decided ultimately on a fixed income portfolio funding curve. This can be adjusted, things can change, the performance of the funds can change. We essentially are looking at about a $225,000 annual obligation, but again, that number I would expect could go up or down depending on performance. The 2012 is in reserves, $1.93 million for SCAPA, so we're good for that. The funding agreement establishes an investment committee, and then P&M will be acting as the operating agent to actually enforce the funding. The second part of that is the San Juan Reclamation Trust Agreement, which is basically an agreement between the SCAPA participants. SCAPA is setting up an arrangement with the U.S. National Bank Association. We're designating them as a trustee, and then we will appoint an investment manager to direct these investments. And then finally, the trust itself will terminate upon satisfaction of the reimbursement obligations, which we project should go all the way out to 2050. In conclusion, we are required to fund some kind of reclamation opportunity. We think this is the most beneficial, the most economic.
And within the agreements, we're also trying to make sure we can allow the opportunity to make a change should a better funding mechanism come along.
Mr. Ivy, did you did you have this checked by Mr. Garber, legal? Did he have a chance to look at this?
No, ma'am, I didn't.
We've been working with the CFO group on this for a while yet.
I'll make sure it gets checked, but
All right.
I have not been involved.
Okay, before he comes back, make sure that he takes a look at it, please. Thank you.
Any board member questions on this?
Yeah, I would also ask the CFO to take a look on these investments, make sure they're not investing in derivatives and some of the other items that get us in trouble.
Well, as Joel mentioned, we'll be investing in fixed income, so we won't be investing in any derivatives.
Any further board member comments?
The payment, is this going to come out of our off-balance sheet reserves?
No, I'd expect it'll come out of the annual San Juan budget from SCAPA. It's they've already billed us about $2 million of the project, $2 million, and our share going forward, as Joel mentioned, is about $225,000 a year.
Anybody else have any comments? If not, anybody from the public? Okay, Joel, thank you. We'll bring this back. Thank you. Okay, we're going to be up on first quarter 2012 surplus salvage report. Donna Gray, you're up.
Good afternoon, directors. This is the first quarter report of the salvage sales for this year, and it's the standard format, so I don't know if you have any questions or...
Any questions from the board for Donna?
Just bring this back for action? Or do you have to bring this back for action? It's just information?
A report. It's fine.
Okay, Donna, thank you
Thanks.
very much. We'll move on. We're going to start into the action items. First one's number 7, invite the state of California to a board meeting to discuss its intent re the Salton Sea restoration. 53. Dr. Hanks, I think this is your item.
Yeah, I'm very concerned after hearing the report from Mr. Osias. He really didn't deal with the restoration issue, but it is an issue that we have to deal with on the Salton Sea Authority. We also have some recommendation to support some legislation coming up, and I think it's time that we get to stay here and get some type of definitive answer from them. What's their plan? They moved forward with their preferred alternative, which was $9 billion, which I think was a signal to everybody that it was the intent was to kill that. But we've in the QSA, we're to set aside $30 million, which is $30 million 2003 or 2006, I forgot which, nominal dollars. So that's, if they're not going to do anything with the sea, and we're putting money into this kitty, where's it going to go? But I think they need to come here. They need to tell the public, the residents of this county, are they going to put $1 into this, or is it going to be a do nothing? If we're going to move forward with mitigation plans for purposes of wildlife and so forth, we need to know what the other hand is doing. Otherwise, we could run into a conflict. And personally, I expect them to come and tell us they're not going to do a blasted thing. But
You'll recall, Director Hanks, some years ago, we tried to bring the lead person on the programmatic EIR, I believe her name was Dale Florkey, to appear before the board. She declined mainly because of litigation. While the litigation continues, there was an earlier question from a member of the audience about why we don't do better at predicting the cost of mitigation at the Salton Sea. under that adaptive management model. One of the big drivers is going to be the state's intentions regarding restoration, because the cost of mitigation will be directly impacted by just how robust that restoration model is. Before the meeting, Mr. Wilcox advised me that there are representatives that he can think of from both DWR and Fish and Game who might be willing to appear and talk about the state's plans. I think that when you first brought this up last week, it was within 90 days, and I think within 90 days we can find someone representative of the state that can address the board.
Well, for one board member, I'm losing patience with them. You know, they want the water to flow, they make all these assertions and promises, and again, we find ourselves getting the short end of the stick. I also would like to know where the board stands on this. You know, we took a position before that we were going to support the state on their preferred plan, which is not going to happen. So I think this board needs to take a stand where they're at on this, and it'll probably come up whenever we get to the legislative part.
Yeah, I don't have a problem with if Bruce Wilcox can get some people down here from the state to talk to us. I don't have a problem with that. I went to all the meetings they had for the restoration way back when, and I now know that Director Hanks and Director Mendoza sit on the Salton Sea Authority, and I can imagine it's got to be very frustrating for all of the people on the Salton Sea Authority for how things are going with the Salton Sea.
Well, Director Hanks, do you want to make a motion to this effect? This is an action item.
Yeah, I'll make a motion that we direct Mr. Wilcox back here to get us some responsible people to come and talk to us.
Second the motion.
Yeah, Bruce, you have any comments on this?
I spoke earlier this week with representatives of the state, and they'd be happy to come down here and talk about both the overall restoration plan and, more importantly, I think, the species conservation habitat, which is, as Kevin said, very, very important to what we're doing in the future. And so at the board's pleasure, we'll have them come down here and present what they plan for species conservation habitat, and they can answer those very questions about what they plan for future Salton Sea restoration.
See if they can come sometime in May.
I don't know why not.
Yeah, so we'll see.
Any comments from the board? Please vote. Okay, thank you. We'll move on to item number 8, the adopt a resolution proclaiming May as Water Safety Month. Jennifer.
Good afternoon, President Menville, members of the board. IID is gearing up for its annual water safety program, and during the months of May and June, assembly presentations will be made at schools throughout the Imperial Valley. The goal of the program is to reach an estimated 25,000 students in grades preschool through the 6th grade. This year's theme is going to center on swimming in safe places and reinforcing the need to stay away from the district's canal system. The budgeted project cost is about $120,000. This includes school outreach activities, paid media, coloring books, branded promotional items, and interactive educational materials. In recognition of water's vital role and the importance of treating it with respect, staff is requesting that the board once again proclaim May as Water Safety Month.
Does it go to all schools besides public schools?
The program is aimed more at public schools, but in recent years, we have tried to also reach out to private schools.
Is there any funds out of this available to keeping the pools open?
A portion of the program is aimed at a summer swim program similar to what we did last year. The portion of this program that's contracted out will reach out to the cities, the Parks and Recs Department, as well as send out donation requests for the local pools to have the free swim program like they did last year. I want to say $18,000 of this program is geared towards the actual swim program.
You know, I just imagine that with the schools and the cities, they're all struggling with the finances. And to me, we might be getting a better bang for our buck to help them keep the pools open than color books.
They are, and as part of the special projects grant program that we did, the awards were made a couple of weeks ago, preference was given, or additional emphasis was given to schools that would use those monies for water safety measures as well.
So out of the 120, 18,000 will go toward helping the schools keep the pools open or the cities keep the pools open?
Yes, going towards that program for the free swim program, the free summer swim.
I'll make the motion.
I second it, but that 18,000 equates to how many kids that can go participate, or how many hours does it pay for the pool to be opened, or how does that equate?
That's dependent upon the individual programs for each of the cities. What this does is this helps with the banners advertising the program throughout the individual cities. It helps with the time that the contractor will take to go out and try to obtain donations from within that community to help fund that program. Those are outreach efforts that this program will help with the cities.
Okay, we have a motion and a second. Is there any more comments? Please vote. Thank you, Jennifer.
Thanks.
Okay, Antonio, you're up on adopt resolutions in support of the 3 legislative bills.
Yes, good afternoon, President Menville, members of the board. Before I get into the 3 bills, though, I just wanted to provide the board with a brief update regarding 2 governors' proposals that we as the district have opposed. One of them being the elimination of the Colorado River Board, and I know that today, I believe John Carter briefed you on that issue already. Essentially, what the governor did in his January budget proposal was he, once again, is trying to eliminate the Colorado River Board. Same thing he did last year, and we opposed it then. We are still in opposition to it. But in addition to that, this year he also wanted to reduce the number of regional water boards, thus eliminating the Colorado River Basin Regional Water Board. So again, we are going to oppose that measure. The May revise is coming up in mid-May, and at that time, if the governor decides to keep both of those proposals and move them forward through the budget trailer bill, at that time we will come back to the board and I will bring you that language and we can take a formal position in addition to what we've already done. So with that said, I just wanted to now switch over to the 3 legislative proposals before you. This is an action item. 2 of them are state, 1 of them is federal. So what I will do is I will actually go over them one by one, and then if you have questions on each of them, let me know, and I will move forward from there. The first one is Assembly Bill 939, AB 939, and this is specific to the Salton Sea governance, and this is an item that the Salton Sea Authority already took a position on, a support position. Same thing with the County of Riverside and County of Imperial, but just in a couple sentences, this is the legislation that Assemblymember Manuel Perez has introduced to shift the responsibility of the Salton Sea restoration project to the local Salton Sea Authority. That would not mean, though, that it would also shift the responsibility of funding. That's not what this bill is intended to do. It is solely the purpose of who is going to be the agency or the entity that is driving the conversation. And I think that goes right into Director Hanks' comments about when is the state going to really prioritize this issue. And I think Assemblymember Perez in this bill is trying to elevate the conversation to that level where he is at least giving us a tool down here to drive that conversation, and that way we're not in the back seat while the state is sitting idle. So that's really what the bill does in a nutshell. This would also eliminate the Salton Sea Restoration Council, which you may recall former Senator Denise Ducheney had introduced that bill. The council was formed and then it never met. And I think that was just another example of the the unwillingness of the department or the executive branch to really put that effort and give the Salton Sea the priority it deserves.
If I'm correct, I think the IID was the only agency that designated a member to that council.
You are correct.
Mr. Wilcox.
Yes, and we were the
The
first
only one.
agency, and we were actually, we told the state that they could host their first meeting here at the IID boardroom, and
Still waiting.
I think they have not yet returned our calls. So if anyone has any questions on this bill, if not, I will move forward to the next one.
Any questions on 939? Go ahead, Antonio. Yeah, go ahead, Andy.
Andy Horn from the County of Imperial. As Antonio mentioned, the County of Imperial has issued a comment letter or a position letter on AB 939. Our position was not a flat-out support letter. It was a support if amended letter. And one of the things, and Director Hanks already referred to this, with the preferred alternative that the state identified. Well, they didn't identify. They selected. Well, they identified a preferred alternative, but they never selected it, never funded it, didn't anything. And the reason is because the legislature has to do that, and the legislature's never taken it upon themselves. The county feels that the only way that process is ever going to get moving is if the Salton Sea Authority, which is the duly constituted joint powers authority among the local jurisdictions that has the power to do this, is designated as the lead agency under CEQA to move that programmatic EIR forward into a project level EIR and actually start doing some work, as well as developing a financing plan to pay for it. So I don't know if you want to consider doing that. And I don't know, Antonio, I could probably get you the information if your letter, if you wanted to amend the letter to support if amended and include that language. And there's just one little section in there where we add like 3 words to the draft to designate the Salton Sea Authority as the lead agency so that they could start moving forward with the project EIR.
Let me ask you a question, Mr. Horn. As amended, meant then that we would be supportive of the Salton Sea Authority plan as opposed to the state preferred alternative plan. Is that not?
I don't think that was included in our letter. Obviously, if the Salton Sea Authority were designated as the lead agency, they might have some certain proclivities to favoring the plan that they have already identified as being their preferred plan. But it's just a matter of, I think the Salton Sea Authority has the idea of doing some, if they were given that responsibility to go back, re-examine what the realities are, do some more feasibility level analyses, finalize their finance plan to the point where they can feel that they actually have the wherewithal to go forward with it, and then kick off the effort to move forward with a project level EIR. But right now that's not being done, and that's what's holding everything up, because the state, as we I think understand by now, has no apparent incentive to do that.
So what we would be doing if we support this action would be setting the Salton Sea Authority as the basically oversight committee, not committing to finances or to a specific plan.
That's my understanding. Our letter just said we would think the Salton Sea Authority should be designated as the lead agency under CEQA to finalize and select a preferred alternative, not their, but a preferred alternative for the restoration of the Salton Sea.
The only wrinkle there that the board should be aware of is your board did pass a resolution in February of 2011 calling on the state to adopt a realistic restoration
and
model.
the Salton Sea Authority is to some extent at odds with our positions with regard to the state board petition, the Coachella Valley Water District and Salton Sea Authority. At this point, we've started to diverge about our concepts of a realistic restoration, so it does create some problems both legally and practically.
The only comment that I will add is that the legislation and not to not adopt what the county is doing, but the legislation is not does not preclude the inclusion of any plan. What this is going to do is it's going to set in motion a process whereby the Salton Sea Authority, which we are members of, will look at all the projects that are out there or that could be feasible projects. There is a date on the actual bill that says that by June 30th of 2014 is when this new process is going to conclude, and the Salton Sea Authority, along with the state Department of Water Resources and Natural Resources Agency, will present those findings of that process. So at that time, whomever the powers may be, whether it's the Salton Sea Authority with our inclusion and the state, will have to come to an agreement, and the legislature and the governor's office will have to adopt whatever plan we tell them is the most realistic plan. So at this time, the bill is not trying to select one versus the other, and I think to tell them at this point, when we have not yet even gone into a feasibility study, that it's in today's terms and today's dollars, there might... Sorry. Yes.
On page 59 for AB 939 on number 2.
What he says is right. He's talking about it, fixing on the
Restore
position.
long-term stable aquatic shoreline habitat for fish and wildlife that depend on the Salton Sea. How is that going to affect the district's decision that if we want to, instead of sending the mitigation water to the sea, we want to transfer it and then build pilots around the sea? Isn't that in conflict with what we would like to do?
I think at this point, and this is from my conversations with Assemblymember Perez's office, the bill, as you see it today, is the first draft. It has not yet been amended, and myself and Bruce Wilcox have been reviewing the language. There are some minor tweaks that we are going to propose, and we have already reached out to the Assemblymember staff that they are willing to look into, but at this time, again, this is the first draft that he has taken before his committee, and they have asked all the local agencies and the stakeholders to take a position if we so choose to, and this is a matter of this board.
Mr. Kelly, what is your recommendation?
I think that what this bill attempts to do is to take the place of the Salton Sea Restoration Council that never got off the ground.
Am I reading more into this bill than I should?
I would think that the safest course would be to simply endorse this conceptually and work toward a consensus position on restoration. My understanding from Mr. Wilcox in the past is that nothing we are proposing in the petition would preclude even the most robust restoration plan. Is that right?
That is correct, yes.
Thank you. Yeah, that's correct. It doesn't. We've spent a lot of time working on the language of this bill, and I think that I agree with Andy that at a concept level, this is a good thing, and we should support it. And the devil's always in the details, but we do need to ask for some language changes.
I think part of our problem here is that, the board has taken action, what we support and so forth, but yet our actions, our arguments in court, our mitigation efforts are not aligned to what we're saying here. And whatever's going to be, if we're going to go with the concept to dry up the sea, then we need to tell the people. If we're going to go with, we're going to make it a pond, then we need to say so. If there's going to be some form of restoration that was agreed to contractually with the state of a number of provisions, including recreation, then it needs to say so. And that's why I want the state to come here. What are they committing to? I think we'd be better off with the locals being in charge of this. I can support that. Right now, as far as picking one alternative over the other, I would hesitate committing to that till at least until the state people come and talk to us. But we have to become more uniform in our thoughts and where we're headed, and along with our actions.
I think that our position on Salton Sea has been scattered, and I think the only thing that we really can say with certainty is that we, even though we're on record as supporting the preferred alternative, we all agree that it's highly unlikely.
Okay, well, Mr. Kelly, what do you recommend to this board that we do with this?
I believe that you ought to support the.
Okay, so is there a motion to this effect? You want to do all three, or you want to take them individually, Antonio?
Well, we can discuss them individually, and then at the end, if the board wants to take a different position than the recommendation by staff, then I think we could break them up at that point just for voting purposes.
Okay, go
on
on.
to the next one.
Go on to 2205 then.
AB 2205 regarding geothermal plants, and what this bill does is it allows that existing regulations that apply to current geothermal plants and the process of extracting byproducts would also extend to material extraction, and that's just another way of saying lithium. The sponsor of this bill is Symbol Mining, and they do have operations here in a local geothermal plant. What the Assembly member is trying to do, this is more than anything, it's what we call a cleanup bill to extend those regulations to include this new cycle, or I'm sorry, this new process of the extracts from the brine in a geothermal plant. So he's just kind of leveling the playing field and ensuring that the operations are also extended to the byproducts of the geothermal plants.
What's the next one about?
Any questions on this one?
Any questions? Okay, go on.
Okay. And finally, Senate Bill 2109. This is actually a federal piece of legislation, and this is regarding the ongoing settlement dispute between the Navajo, Hopi, and the Colorado River Settlement Act is what it's being dubbed. And this bill would approve the settlement of water rights claims of the Navajo Nation and the Hopi tribe in the state of Arizona to authorize construction of a municipal wastewater project relating to their water right claims, thereby resolving litigation against the United States Department of Interior Bureau of Rec concerning the operations affecting the states of California, Arizona, Nevada, and that is the only reason why this is before you today. This is litigation that we are defendants to, and Jeff Garber, I think I will default to him with any specific questions on the bill.
We're
Jeff,
monitoring.
did you have a chance to review this?
We're an interested party in the litigation because some of the claims have been to Colorado River rights. This settlement would resolve those claims without touching
It's your
our
recommendation
interests.
to approve
We should
this?
support it, yes, ma'am.
Okay, so I move to support these three bills.
Is there a second? Somebody second it? Okay. Any further questions? Please vote. Okay, thank you.
Thank you, Mr. Ortega.
Okay, we're going to move on to number 10. Take appropriate action on the procurement bid policies, numbers 3101 and 3130. And I think, Vance, you came back.
Yes, I'd like to
Congratulations.
Mr. Taylor is a brand new father, and he's on baby leave, but we forced him to come in today to handle this matter, so that's why he has bags under his eyes, and I hope you'll show some sympathy for him.
6 days today.
Oh, little girl.
It's a girl.
Is that a babysitter?
Congratulations.
Thank you. Good afternoon, President Menville, members of the board, Vance Taylor, Assistant Counsel. Staff has placed on today's action agenda 2 draft procurement policies. Policy 3101, which applies generally to the procurement of goods and services, and policy number 3130, which applies specifically to competitive solicitations. These policies are the culmination of several months of hard work by a cross-functional team of staff in collaboration with 2 board members to try and develop a fair and more transparent procurement process. Staff believes that the 2 draft policies before the board now represent a significant step towards those ends. Most notable among the changes incorporated into the new policy are the adoption of the lowest responsible bidder methodology on all sealed bids, Secondly, there is a provision for the pre-qualification of vendors and professional service providers. And lastly, an appeals process has been incorporated whereby a solicitation participant may appeal the award of any district contract. The new draft policies have come before the board on several occasions, the most recent of which involved the last week's comparison of the draft policies against the provisions of the Public Contracts Code applicable to cities. Thus, I will not ask the board to slug through these policies again with me. At this point, staff believes that the policies are ready for action and we're presenting them for action. However, if the board has questions prior to acting on this item, I'd be happy to try and address those if I can.
I'd like to move to accept, to approve.
Actually, I would like to
He has a statement he
just
wants to
offer a proviso for the board's consideration. And with your indulgence, I'll read it. A great deal of time, effort, and money has gone into the development of the procurement and bid policies before you today. They have undergone a thorough legal review and been vetted in open session with the public. The fundamental question now is whether these policies taken as a whole add up to actual reform of a system that, admittedly, has fallen well short of the standards of transparency and accountability expected of a public agency. That's why I am recommending to the board, should it decide to approve these policies today, that a bid policy oversight committee be formed under the direction of the ethics officer, and that its first task be the creation of the standard operating procedure that will guide their implementation. Internal audit and the project management office should help staff this committee, I would think, and its chief concern should be to ensure strict adherence to the safeguards already built into the bid policy, including pre-qualification of prospective bidders, the right to appeal a decision of the evaluation committee, low cost being assigned a greater percentage value in the evaluation process, and a written justification when the lowest cost proposal is not selected. I would further recommend that this SOP come back to the board for its approval prior to the implementation of these policies, and that the oversight responsibility of the aforementioned committee extend for a full year. I am mindful that this extra layer of due diligence will impose additional cost and delay on the process of awarding contracts, but it is a necessary component of moving the process forward and imbuing it with certainty and confidence.
Okay, let me understand what you just said. Your recommendation is not to approve these policies today? And to delegate purchasing to work on an SOP?
No.
Actually, should the board move forward, I would ask that Mr. Taylor, as ethics officer, impanel what I am calling a bid policy oversight committee.
Okay, I heard you. Okay, so I move to approve policies 3101 and 3130 with your recommendation, Mr. Kelly.
Is there a second?
A second. Comments?
Discussion by the board.
Kevin, as general manager, you've been here 8 months, right? It has been 8 months?
It's going on about 18 years, I think.
When we talk about this policy, I know that we bring up staff has put in a lot of hard work. What does that mean? How far down does this go for input? Did it stay with Vance and Carl, or I don't know who else, or did it go down 2, 3, 4 layers to provide more minds, more people input, everybody who's actually affected through the bids? Because I'm sure everybody in staff, when it keeps going down, everybody is doing probably the best at heart for the district.
I think it was very deep into the organization. I think it was an exhaustive process, and it's just in the sheer heft of the documents, you can tell that it's comprehensive. I don't think that Mr. Taylor has been involved Have you been with it since the
Oh,
outset?
yes. I've been involved since the inception. We've had the involvement of internal audit. We've had representatives from finance, contracts administration, probably leaving somebody out. But we had, I think, a pretty good representative group of the various departments that are touched by the policy present. And, of course, we had two board members
And the reason
as
I
well.
ask that is multiple reasons. One is your management style. I know from the past, some would say that the top management made all the decisions, policy, so to speak, and it's not blame the 3, 4, 5 layers down, but let's blame the top. And it's good to know that multiple reasons. It makes good for management practices that people are involved and they're not just sitting there because they get them paid and they want to work and they want to provide input, because I think everybody, if you're getting paid by the district, you need to put your input what you're getting paid for, so to speak. And so this is one of your third, fourth, fifth policy in the last 8 months that's really been high up there and controversial. And I'm not such a nice guy that I'm not going to hold you responsible, just like the line out with your negotiations with San Diego, which I will hold you responsible. Sorry, I'm not that nice of a guy that I wouldn't. But I think as time goes on, we will see whether these policies work or not work. And at the same time, I think there's always room for improvement. And because we're not going to be perfect, I think you will be improving on it. And it'd be nice to see you continue to work and continue to improve these policies. And one of them, showing great leadership, good leadership, is this with Vance, as far as being the head of even oversight the bidding process created by a deep level of many of the people that work for the district.
Well, I'd like to commend Mr. Taylor and our staff and the board members that participated. And I think there were also some members from the outside that also participated. They were asked to participate, whether they took the opportunity, I don't know. But this went from a 2-page document to 16 pages.
It's
So
a significant
it's
step in the right
significant
direction, I
improvement,
think.
yes. So I commend you, and I'm ready to vote on this.
Just before you do, if I can, I don't want to, I don't mean to try to duck the responsibility for it, but I wasn't involved in I can take neither the credit nor the accolades associated with this process. It was done at an operational level. There was board member involvement. It has become controversial. And I think that the lingering concern is that no matter how comprehensive the document, you cannot people-proof the policy. So I do think that this year-long oversight function, with some regular reporting back, it may be tedious and it may add some cost, but I think that the board can have some measure of confidence in the end product.
Well, the fact that you have PMO and internal audit involved, I think, will make this a more smoother process.
Is there any other comment from board members? Dr. Hanks or Dr. Desert?
You know, this has been an issue's been ongoing, and it's just, to me, just been resistance trying to get to where we need to be. It may be the best plan. You know, it's the board's responsibility to make sure that the financial controls are in place. That's our duty. And if you have the best plan, I don't know whether there's a perfect plan to try to get these controls in, and then you don't have the people in there that support that plan, that believe in what you're trying to accomplish, it's still going to go on. Personally, I would prefer a policy where the specs were defined, understood, where you had qualifying bidders that would apply for it, and there was a pre-qualification round, And then there was a low bid, which was award to the low bid, which was the best and final offer. Whenever they turned in that bid, that was it. If, in the minds of the staff, the value wasn't there, then it could be brought back to the board to suspend policy, rebid, or award to the next bidder. This has been ongoing, and the oversight committee, I think, is a big addition to it. But I think it's gone on so long that I'm looking for something just real hardcore. I'm sorry.
Hey, Director Desert.
I have no comment.
Okay, well, I was involved in this with Director Desert. I know we went through about 10 meetings. They lasted a couple hours each. We went through both of these policies page by page, and multiple people from different staff departments were involved in this. I know this. I think Mr. Garber said it's got more bells and whistles on it than probably what we need, but that's where we're at. We're going to try it out for a year. I know that Mr. Duggins is here from CoLab, and I know Aaron's here, so I don't know whether they have any comments that they want to make. So, you guys want to come forward? You got any comments, Mr. Duggins?
Jim Duggins with Duggins Construction Company. And the bid process used mainly throughout the state of California by governmental agencies is a state contracting code. Your code, or whatever you're putting in, works to about 95% of that. There's a couple of things that are put into place that really give you guys a pain, and it gives the general public a pain. And I think, that's what we've asked. I sent you a letter a while back, and in that letter I pointed out that in your evaluation process, the way it's been being done, absolutely opens you up for manipulation by staff. And I'm not making any comments because I think IID's got some great people working for it in every division. They have had for years. But you can have 1,000 people working for it, and you have one or two bad ones, and it makes the turn bad. Take that out of their hands. You're the board of the directors. Take it out of their hands. And all I'm asking you to do is use the state contracting code, but take that caveat out where your evaluation process is done on the backside. Because when the bids are opened and then you have the evaluation afterwards, they can eliminate anybody they want. And even if it's done properly, it has a bad look to it. So if you're going to do it for 1 year experiment, I think that you need to look at it and get a little more input from the private sector. And by doing that, I just think as it's written, it's still vulnerable to manipulation. And I wouldn't approve it, but I don't know all the things that you guys know and how you're going to do it. I liked what your general manager said about, putting something in place so that we can. But the bottom line is, the way it's written is a version of the way it was. The state contracting code, the state pre-qualification code takes all that out of play if it's done in the proper procedure. So I'm just asking you to follow the proper procedure, get it right, and if you're going to put your stuff out to bid, give it to the low bidder. And make sure your pre-qualification is done up front. Prior to the bid opening, if you're going to eliminate somebody, eliminate them before the bid's open. So everybody that opens that bid, every bid that's open, is qualified to make the bid, take the low bidder, takes you guys out of hot water, makes everybody feel a little more comfortable, and I think that's the way it goes. So that's my comment, and thank you for your time.
Can I ask a
Mr.
question,
Garber? Mr. Garber.
Even if you pre-qualify, don't you still have to look at the bids to make sure that they're responsive?
Yes. What you do when you pre-qualify the bidders, okay, on the state side, when you bid a governmental job, all these pre-qualified bidders are given the chance to bid the job, okay? If one's deemed so let's say you start with 7, now you have 6. Those people all bid it. They take the low bidder. Let's say the bids are at $1 million, $1.2 million, $1.4 million, and there's somebody at $500,000. They have the right. That guy's the low bid. The agency has the right to bring him in and say, sit down, let's qualify your bid.
But don't you have to look at the bids, even if you pre-qualify, and make sure they're responsive? And I don't see how you can get around that. In other words, sometimes the bids are not consistent with the RFP.
You can't. Yes, you do need to evaluate the bids. I understand that, but
That
you don't.
yeah,
but you
okay.
don't. You
So
don't.
You're not saying don't do that.
I'm not saying not
All
do
right.
that. I'm saying don't evaluate. Have your evaluation where you eliminate a bidder after the bid opening, and that's what you've done.
But isn't it possible that when you get a bid and you open it up and you go, oh my God, this bid's not responsive?
Then you need to bring that bidder in, sit him down, and say your bid is low, and you have not met these qualifications. Most of the time, the bidder in the governmental state that I've been involved in, the bidder says, "Oh, I'm going to walk away from this because I have an option to walk away from it." Okay, because basically you're qualifying. This is what we expect from you, and he's thinking, "Well, I can do it this way," and you're saying, "No, you can't. You're going to do it this way." That's the qualification I'm talking about in the evaluation. But what's happening? The perceptions there is where you're evaluating you're putting it out to bid, bringing all these steps in and having the pre-qualification done at the same time, or the evaluation done of the bid at the same time turned in. So it's going into private, it's going into you guys where the public doesn't know anything about it. And okay, they know where the bids are, but then they evaluate it. And even if you're 100% right, the perception out there is that you guys are being dishonest. And it's not fair to your people. It's really not fair to your staff.
Corrupt's the word to use.
Yeah, exactly. Yeah. But I didn't use that, and I don't believe that. But the bottom line is, I am telling you that's the perception out there. Well, hey, they're playing games with it. So take it out of the evaluation. Basically, pre-qualify your bidders and do an evaluation after the bid, and they do that all the time when a bid comes in. If you always bring the low bidder in and you talk with him and you go through the bid with him and you say, this is how we expect to be done. This is what we expect. This is what we expect. Yes, yes, yes. And a guy might say, well, maybe it's $100,000 difference. He goes, no, I didn't do that. Well, you know what? That's how it's going to be built. And we're not going to eat it because we have a bidder right here that's $20,000 over you that says that they've done it that way. He's going to say, no, you either stick to it for your bid or they go the next bidder. That's what gives you guys the option to do that evaluation. I'm talking about the pre-qualification of the bidders. Don't do that evaluation and eliminate them afterwards without the proper procedure.
Mr. Taylor, can you answer to his concerns?
I'm not sure that our policy doesn't do that. I mean, it depends.
How does that play
We do
into
have a portion of the policy that provides for the pre-qualification of professional service providers and vendors. Essentially, the way it would work is that we would establish a methodology for pre-qualifying the vendors to determine if they were capable of doing the work and completing the job. And once they were pre-qualified, then it would go on to phase 2. And we would treat that as a lowest responsible bidder type of methodology. And this is the process that we would use on sealed bids. So there is a process for pre-qualifying sealed bids in the policy as it stands now.
Yep. Jimmy, on this deal, I know that we've spent a lot of time, and I don't know what all interaction I had with CoLab with Aaron, and I know Lori Franks got up here and talked last week about she tried working with Aaron on some of these things. But Mr. Kelly's got a deal in here that it's got Mr. Taylor that's going to be looking down on this thing, and internal auditors and some other people to try this thing out and see how it works out. Doesn't work out, you adjust it again. But I mean, we've come a long ways on this thing, Jimmy. It may not be. You said it was 95% perfect. Is that what you said?
Yeah, and even there's none that are perfect. We know that.
No,
There's none that
there's
none that are infallible because
and
there's always
some
the
issues
human element that will take advantage of and find a way around it. But the bottom line is that I think we're all on the same team here. I really do, and I think that we're all working the same direction. But I do caution you that I like what you're saying. Put a system in and try it for a year, but you got to be very careful in the way it's written and the way it's done, because it can go back to the same old way.
Yeah, but we don't want to go there.
After a year, it goes back to it has a tendency to go back the same old way. So the bottom line, guys, is do your pre-bid qualification, And then after and it says in the state code, if you look at that, when you pre-qualify a bidder, if you eliminate him from bidding the job, okay, you have to do it prior to the bid opening. And then then he has a right to come back to you, which you've put in there. It's kind of one-sided because like kind of going to an IRS board that he's got to go back to the IID to plead his case. But the bottom line is you've got the elements in place, and someone made the statement a while ago that the human factor always comes into play, and I agree with that. But the bottom line is, guys, get the pre-qualification done up front. Everybody that bids is equal or considered equal. When the bid's done, then you can do an evaluation, but not of if they're qualified to do it so you can eliminate them. And that's the precept that's out there now.
Mr. Duggins, I've first got on this board, I've always said we need to somehow figure out how to curb bad human behavior. And so you're hitting it on the nail of the head. And when I began talking with General Manager Kelly and his management style is that he's had 15, 20, 30 people in the room where that making it harder for that one or two people to come up with ways or ideas that will be the cause of bad behavior. When you have that many people in the room, it's harder. Doesn't mean it can't slide through, but it does become harder, and it will pop out in that many room of that big of a room of people trying to put this thing together, which the district has done. But I think Mr. Taylor said there is a process for that pre-qualification bid, and I can see that's doing this for a year. And if Mr. Taylor can explain to you that pre-qualification bid, and then if it doesn't work and it doesn't really curb the human behavior like we want it to, I mean, I don't know about you. I mean, I don't think you're a big regulation guy, where we could actually put more regulations in there if we need to. But I think Mr. Taylor can probably better explain to you that process as far for pre-qual.
Mr. Sanchez, I think less is better, and I agree with that. And all I'm telling you is that you put it in there for a year and you watch it closely. After that year, you have to continue to watch it. Yep. And the bottom line is you get the pre-bidding deal is part of it, but the evaluation of the bid, don't let the evaluation system eliminate one or two bidders and give the perception out there that there's bad stuff going on. And that's what's happening. Maybe it's right. Maybe it's totally right. It's what happened. But lay it on the table and do it up front, because you've got the situation right now where the one that blew it all up and everybody's looking at everything else, where you take the third or fourth highest bidder. Well, the other people were qualified in certain instances, but maybe they weren't qualified for the IAD, but they weren't told they weren't qualified till after the bid was open, after everybody knew the prices. And that's how it was done. And it just blew the lid off of everything. So
we've changed that. We were in the process, and we worked hard to change that situation.
Yeah. Well, if you do, I hope you stay on it and keep watching it.
Well, he's got Vance right there.
And I'm here as Duggins Construction, and these are Jim Duggins, and these are my opinions. And okay. I'm not here.
Well, I appreciate you.
I just want you to understand that, because this is a very big, important item to me. It affects a lot of people, and it affects you guys. It really does.
Call us corrupt.
Pardon?
Just don't call us corrupt.
I never have.
Okay. Any other comments from anybody?
Please
Good.
call for the question.
Please vote. Okay, thank you. We'll move on to item number 11, approval of major work authorization, $100,233 to cover the central drain number 6 pipeline work. Ismail.
First of all, I want to apologize for the last meeting.
You weren't too tardy.
You snuck away.
Well, I guess the meeting was changed, and
Well, at least you were at your office doing work. So
I was working, exactly. I was working. Anyway, we are here. Good afternoon, members of the board, Director Menville. I'm here to ask for approval for the major work authorization for the central drain number 6. The central drain number 6 is a pipeline that was installed in 1964. In the last 10 years, we have kind of failures on that pipeline, so we kept a record, and it has gone up to $100,000 in the last 10 years. So we are proposing to replace a section of the pipeline that it has a couple sinkholes or problems, separations of the pipe, basically.
I move to approve
okay, is there a second?
NWA.
Is there a second? Any questions from the board? Please vote. All right, thank you, Ismail.
Thank you.
We'll move on to item number 12, approval of bid number 12-1 to Lidco for installation of seepage interceptor line at the East Highline Canal DP-27.
I move to approve.
Okay. Is there a second? Okay. Any questions? Please vote. Okay, thank you. We'll move on to item number 13, adoption resolution and change of the district's open access transmission tariff wholesale transmission economic development rate.
I move to approve.
Chris, second? I'll second it. Any discussion on this from the board?
I think we talked this to death.
Okay. Anybody from the public, please vote.
I think it's a good move forward, and hopefully it'll help our solar developers.
All right, please vote.
Late.
Thank you. Item number 14, acknowledge receipt of the March 2012 Energy Cost of Judgment Report. Sandra?
You moved very quickly all of a sudden. Sorry for the delay. Sandra Ainsworth, Controller Energy Department, with the March 2012 EC update. This slide looks a little bit small. I wanted to point a couple of things out to you as I go through the calculation for March. The first thing that I wanted to point out to you is that fuel and purchase power total year to date for March is $33.8 million. That is $12.5 million under the budgeted figure of $46.3 million. Just real quick, some insight to what's driving the budget variance is approximately $6.2 million is directly attributable to a combination of demand reduction programs that haven't come in. We haven't spent any of the $1.2 million budgeted to date. And there's been a very small expenditure, $212,000 versus budgeted figure of $5 million for renewables through March year to date. Just want to point that out to you because both of those, the renewable, we expect those costs to start coming in May, so we'll see those costs start increasing for the remainder of the year beginning in May. In addition to the current projection is that we will spend approximately 80% of the $5 million budgeted for the demand reduction. So I just wanted to point out that that's a 50% driver of the budget variance March year to date, and we anticipate that those figures are going to start increasing for the remainder of the year beginning in May. In addition, energy cells that offset the cost in the formula its gas cells have been increased above budget, and that's due directly to the fact that the Yucca plant has been out and we've been selling the gas for that plant. The plant, as you know, came back online in April, so beginning April, we expect to see the revenues start to fall from sales. So we'll go ahead and go through. You're used to seeing this calculation. I want to point out one additional thing in the calculation before I get to the final outcome at the end of the calculation, which is I've circled in the kind of in the middle of the slide here, the renewable ECA component. I've talked to this before, but just wanted to remind the board that beginning in June billing for May meter readings, that we will be breaking out on the customer's bills the ECA into a non-renewable component and a renewable component, so that they will actually be able to see which portion, how much of their bill is directly related to the renewable portfolio standard. So once we go through the calculation, the over collection rather for the month of March is $3.1 million, and what that is doing is that is adding to and increasing the cumulative over collection for 2011 and through March year to date 2012 to $47.3 million.
Any questions for Sandra? Go ahead. Okay. This is an action item, so. Okay, is there any discussion?
What's the plan on the adjustment?
We will be back before the board as soon as we have the first quarter numbers complete, the final numbers.
Okay.
Director Hanks, that quarterly adjustment hasn't happened yet, and as the board knows, we are adding renewable resources in the month of May. So we will be back to you with a going forward plan that addresses that changed circumstance.
Okay.
Okay, do you have any more questions, Mr. Hanks? No. Mr. Benson?
Steve Benson, Brawley. I just had a question. The 47 million, I understand it's an overcollection, but the intended use of that was to go to the renewable, and it's just been accumulating over time, right?
The intended use of that is that can actually go against any portion of the power supply budget.
Okay.
So when we actually bring the quarterly update back to the board, it will have reflected in the calculation and in the recommended rate an offset for the overcollection. That will be rolled into the calculation.
And that it can be used going forward as well for power increases, or what's the intent of keeping it?
I think it's the board's intention to offset or to give it back to ratepayers.
Okay. And then there's another 100 million. It's the rate stabilization fund. What was the intent of the rate stabilization
I
fund?
think it's the same, but in both instances, it would take an affirmative vote of the board.
Yeah, it might be helpful if Mr. Benson was given a copy of the resolution that we attached to the budget. I think it has a pretty well-documented plan there.
All right.
Just for comment, I know it wasn't my intention necessarily to get 47 million on top of the 100 million. It's just that every time we cut the ECA rate, it dropped even lower than that. So we cut it twice, but we couldn't catch up to it, and gas just kept free falling.
That's absolutely a great point, Director Sanchez, because in the figures that are being represented, we budgeted at gas at about 497 per MMBTU, and it's actually coming in on average about 295. And if you've seen the projections right now, there was talk a few weeks ago it might fall below a dollar. So.
Okay. Do you have any, Oscar? You got a quick question? You got to go to the podium, Oscar.
Oscar Gonzalez, 844 Encanto Terrace, Calexico. You know, Mr. Kelly, I was very proud. I mean, I'm overwhelmed that you said that the board of directors want to use that to lower power rates. I've been waiting for that for many, many years. Even my father used to say that. He died in 1978 when they were going to lower the rates. I don't remember at all when the rates were ever lowered. Thank you.
It's because we held steady.
Okay. Anything else, Sandra?
Call for the question.
Please vote.
That's not on this
Please
item.
vote. Thank you. We have 2 items left. Number 15, approve the reallocation of funds for the Coachella Valley Substation Bank Number 4 Transformer Addition. So go ahead, Sandra.
Before you have a request to reallocate the funds. The project for the Coachella Valley Bank 4 breaker addition was brought before the board at the board meeting last week, and you approved it. So this is really just to formalize the budget transfer for that. In the MWA that was presented, these funding sources were identified. So this is a matter of formalizing the transfer.
Is there a second?
The projects that
Let me get a second. Did you second it, Jim? Okay, so go ahead, Jim.
The projects that you're pulling or replacing, what was the priority number that was given to those? Are we still giving priority numbers to these projects?
We are prioritizing, but that's one piece of information I did not look at. I can get back to you on that.
Well, I would hope that you were taking the lowest priority ones.
Essentially, that's what we would do. However, as you know, sometimes priorities change throughout the year, so some of the new considerations need to be taken into they need to be considered,
Somebody's
how things
got,
have changed.
somebody's got to be able to answer that for me.
Yeah, and if no one can, we'll find out later in the day. I'd like to know that too.
Need to get back to you. I don't have that with me, but I will respond and provide that to Jennifer Goodsell to forward to you after the board meeting.
Director Hanks, I don't know exactly what the priority number is, but they are in fact lower priority projects. The digital control systems for one of the hydro upgrades is a project that we have the opportunity to be able to defer if we needed to.
So there's no damage if we defer it. We're not cutting the heart out to fund this, right?
That's an efficiency type project, so it takes advantage of better use of your manpower resources. So we can certainly defer that if we needed to.
And the other project, the other transmission project, actually the projection is we just will not spend those funds this year.
Any further questions?
I've got a question for Joel. Joel, so what we're going to have up there when this is finished is 3 transformers. The 2 existing transformers will be wired somewhat like as a team or in parallel, and then those 2 will match the new transformer that comes up there.
That is the intent. It give us a little breathing room on the capacity.
A little breathing, that's right. And then, but if something happened and we lost one of the smaller transformers, would we still be able to function through the power, run power through there?
Yes, and you've got the full capacity of the remaining 300 MVA unit,
okay.
So we should be in very good shape.
And then if we lost the big one, the 300, we would still be in the same position that we were at currently.
We're more or less where you are today, so
right.
We're in good shape.
And the impedance and the way the transformers all match and balance each other, they're going to, the electricity will, the electrons will flow properly. We won't be having too much line loss or loss of efficiency.
It changes the power flows in the system. We're going to have to take some future looks at the transmission in the area, the 92 kV transmission, and make some additions. But for now, it gets us some capacity breathing room. Okay. That's much appreciated.
And the anticipated finish date for this installation?
Still shooting for on or about June 1st, I believe.
June 6th, I heard.
Yeah.
There's some bus work that needs to accompany this. You could very well be seeing an amendment to the 1.9.
Carl has a comment.
We're looking right now, the MWA said June 1st. It's a high-level schedule. More definitively, it'll probably be mid-June, and there may be an amendment with the cost we're getting back on the move, and then the firewall in between there. So you may get an amendment on this. We're moving pretty quickly on this one.
Okay, please vote. Thank you. The last item is the approval of the quitclaim deed in favor of Curtis John Corda and
I'll
Julianne
make that
Corda.
motion to approve.
With it. Okay, it's been moved and second. Please vote. Thank you. That's the end of the meeting. Thank you.
Gloria.